It has multiple counts. The first count alleges the offense of assault, family violence, second offense. Count 2 alleges that's an assault by choking or strangulation, second offense. Do you understand the indictment that is filed against you?
Yes, ma'am. Yes, Your Honor.
State, how are we proceeding?
Your Honor, the state is going to waive count 2 and proceed forward only on count 1.
No objections.
Count 2 is a second-degree felony, Mr. Guzman. It is punishable by confinement in the Texas Department of Criminal Justice, the institutional division, for any period from 2 to 10 years confinement. It also carries a possible fine of up to $10,000. Do you understand the range of punishment that applies to the charge?
Yes, I understand, Your Honor.
You have the right to a jury trial. You have the right to cross-examine all the witnesses against you, and you have the right to remain silent. Those are your constitutional rights. Do you understand those?
Yes, I do, Your Honor.
When you sign the document that I have on the screen, what you're telling me is you want to give up those rights. Is that what you intend to do?
Yes, Your Honor.
Is this your electronic signature on the that I'm showing you on this page?
Yes, Your Honor.
Are you a citizen of the United States?
Yes, I am, Your Honor.
If you are not a citizen, I'm still required to tell you that a plea of guilty or no contest to this charge could result in deportation, exclusion from admission to the country, or denial of naturalization under federal law. Mr. Guzman, are you satisfied with the representation of your attorney?
Yes, I am, Your Honor.
Mr. Kagan, does your client have a rational and factual understanding of the proceedings against him?
He does, Your Honor.
Has he been able to assist you in the preparation of any defenses?
He most certainly has.
And in your opinion, is he mentally competent to waive his rights and enter into a plea?
Yes, he is.
I will accept the waiver of rights and make it part of the record. Mr. Guzman, on the screen, I'm showing you the plea bargain agreement that you have made in this case. I'm going to read it to you. I want you to tell me if this is your understanding of the agreement that you made. It calls for a recommendation of deferred adjudication for a period of 4 years. There's a $1,500 fine, an affirmative finding of family violence. That's an agreement as part of the plea, a TAP evaluation, plus follow the recommendations. You're going to do the batterer's intervention prevention course, no contact order with Angelina Mann. 150 hours of community service. Is that your understanding of the plea bargain agreement?
Yes, Your Honor.
Mr. Kagan, is that your understanding?
It is, Judge, but I would also like to add that I explained to Mr. Guzman that down the line, he would be eligible for early termination if he completes this ahead of time.
Yes, that's always an option in my court.
Thank you.
State, is that your understanding of the agreement?
Yes, Your Honor.
What is your plea to the charge of assault? Second, that's assault of a family member as alleged in count 1. What is your plea? Guilty, not guilty, or no contest?
No contest, Your Honor.
Are you pleading no contest because you have talked about this matter with your attorney and you believe it's in your best interest to do so?
Yes, Your Honor.
And are you doing this freely and voluntarily?
Yes, Your Honor, I am.
Has anyone forced you to enter a plea today
No, Your Honor.
or offered you anything in exchange for your plea?
No, Your Honor.
I will accept the plea of no contest. I find the plea is voluntarily made, and I will ask the state to tender its proof.
At this time, state offers States Exhibit 1 and attachments into evidence, Your Honor.
States 1 is admitted. I'm sorry, any objections?
No objections, Judge.
States 1 is admitted. Mr. Kagan, are you satisfied in this case that the state has complied with Article 3914?
I am, Judge.
I will sign the discovery acknowledgement and make it part of the record. Give me just a few minutes to read the evidence and I'll come right on.
Okay.
Before we go back on the record state, I'm going to have to get some answers on the no contact order because apparently they have children in common. So is there a court order that allows him access?
Not to my knowledge, we lost contact with her a little while ago.
Is there a protective order?
Let me double check.
All right, I'm still reading, so let me know.
Travis, can you go to 8?
Judge, for the no contact order, it looks like one was filed, but it doesn't look like it's been approved. And she did say, tell somebody in January for the no contact order that they no longer needed the restraining order, and that, you know, they want to be involved with the kids. Or he
And
wants
Judge,
him involved with the kids.
and Judge, based on that, I would ask the court to change that to a no harmful or injurious contact order.
I just want to make certain there's no protective order or no custody order that it would conflict with. So that's my question. There was an emergency protection order back when the case first started. Mr. Guzman, do you see your kids regularly?
Yes, well, my children, actually, ma'am, Your Honor, me and Angelina, man, we do not have children together. So I don't know. Yeah, we don't have children together.
Okay, so there is no need for you to contact her. You can abide by that.
Yes, ma'am.
Okay, let's go back on the record, please.
Excuse me.
I do find the evidence is sufficient to substantiate your guilt. I will make no other finding at this time. I will grant the application for deferred adjudication for a period of 4 years. There's a $1,500 fine, an affirmative finding that family violence was committed in this case, and that is by agreement. We're going to do a TAP evaluation, follow the recommendations. You have to complete the batterer's intervention prevention course, no contact order with Angelina Mann. And Mr. Guzman, that means no contact. That means no WhatsApp, no Facebook Messenger, no Instagram, no nothing. You don't contact her. Even if she contacts you, this order pertains to you. So you have to abide by it. If there is a need to change the no contact order, it's very easy to do so. You just have to tell your probation officer and that officer will contact me. So if there's an agreement to change that in the future, that's absolutely fine. I know things change all the time, but you can't violate it and then ask for it to be changed. You have to change it first and then have contact with her. There's also going to be 150 hours of community service. Mr. Guzman, this is a plea bargain case. I did follow your plea bargain agreement. You do not have a right to appeal. Do you understand that?
Yes, Your Honor, I understand.
Okay, what I'm gonna do now is I'm going to put you in a breakout room. You're gonna talk to my probation officer, and then you are going to be given instructions on how to report after today. All right, we're gonna go off the record on this case.
And I'll go in that room too, Judge, if you can.
Okay, Ashley will move you, Jerry. Kate, thank you for coming back. We finally got it done.
Right, had my fingers crossed.
Didn't lose hope.
Right, right.
Ashley, if you can move them over, please. Where's Miss Cutter? Gretchen is in the back office if she needs to go talk to her.
Yes, I am. I can come in the courtroom if you need me to, Judge.
That's okay. She's coming to you. Is everyone here on the Barrientos Vela case? And we can take care of that really quickly. I see Dawn, I see Oscar. Oh, she's here. She can sit in the other table.
And Christian is on also, Judge.
Morning, Judge, or good afternoon, Judge.
Oh, I see Christian. Okay, so Ms. Vela is present in the courtroom. What I'm going to ask her to do is sit at council table so she can have a mic. And you guys can hear her on Zoom. Is that okay, Mr. Goss?
Yeah, that's fine.
Mr. LaHood? Okay. Ms. Vela, if you can come sit in that table and give her a Zoom mic, please. I need a docket sheet for Vela, please.
On the way, Judge.
You ready? You set up?
She said it.
Okay, make sure it's green. Go ahead and hit that button. Yes, ma'am. Let's go on the record. This is cause number 2021 CR 4408. The state of Texas versus Michelle Barrientos Vela. Attorneys, please make your announcements for the record.
Dawn McCraw for the state.
Oscar Salinas for the state of Texas.
Christian Newman for the state of Texas.
For defense.
Nico LaHood for Ms. Vela.
And for purposes of the record, Ms. Vela is appearing in person in my courtroom. She does have access to the Zoom. She could see everyone on Zoom. Any objection to proceeding in this hybrid format?
No,
No, Your Honor.
Okay. I called the attorneys for both sides this morning and I convened a hearing so that I could go on the record with something that happened that touches tangentially upon this case. Over the weekend, my campaign staff received information that a witness that is involved in this case was told by somebody in the Democratic Party that Judge Meza better do the right thing in this case, or I'm going to find a Democrat opponent for her to primary her. I'm not going to quote that that's what was exactly what was said, but that is the nature of what was said. That did get back to my campaign. For purposes of the record, I am up for re-election in this next election cycle. And if it had been any other citizen of the county of Bexar County, I probably wouldn't have had any issues with that. However, because the context was raised to a witness in this case, in the overabundance of caution, because the most important thing to me as a judge is that Ms. Vela have a due process, and the integrity of this proceeding is the utmost important to me. So I am putting it out there for both sides to know. I am being very transparent. I will tell you that whether I have 0 opponents or 10 opponents, the judicial election cycle has nothing to do with how I handle my business on the bench. I don't believe I have a conflict. I'm ready. She has made her election for punishment. We have a trial setting. I'm ready for the pretrial motions hearing tomorrow, and I don't believe I have a conflict. However, if either side wishes to discuss, not with me, but amongst yourselves, and you don't have to give me an answer today, if you want to file your motion based on this set of circumstances for me to recuse myself, you're going to have a chance to do so before tomorrow morning when we are to convene for the pretrial hearing. If you do file your motion to recuse, you understand the process. We'll immediately put a pause on the proceedings, and Judge Harrell, as the administrative judge for our region, will immediately have a hearing on that recusal. So I'm not going to ask that anybody respond. That's the purpose of today. And I will see you all at 9:30 tomorrow morning.
Your Honor, I'm sorry, briefly. I'm not going to respond to that. I can tell you right now, we do not want the court recused. However, the identity of the person who said this, if they are connected with the district attorney's office, we may want to file a motion to recuse the district attorney. And if so, I would like, if we could, if the court can identify who is the person who said this.
Right.
So that,
The person who said it was Robert Vargas, and for purposes of the record, he's sitting in my courtroom today. If
okay.
anybody wishes to call him.
And Mr.
And I don't know his connection to the DA's office.
All right. And I don't know that he has a connection to the DA's, but I do believe he has a connection to Joe Gonzalez as a campaign advisor. He was paid by Mr. Gonzalez. And so we are not interested in recusing the court. We believe, as you said, that you have the highest integrity, and we would not, we believe that you will be fair. And that's the whole reason we're in this hearing in the first place. However, with that information that it was Mr. Vargas, we do believe that there can be an appearance of impropriety with the district attorney continuing to prosecute this case if a person connected with him and that he employed as a campaign advisor was seen to be threatening a judge or threatening a judge's position on the basis of what the court does in this particular case. And Ms. Velia, we do believe, has the right to be prosecuted by a district attorney's office that is not connected with a person threatening the court. And so therefore, I don't know that we need to call him right now because I don't know exactly, but I think our motion will be more geared towards recusing the DA's office.
Well, I'm preaching to the choir. I know this. I know you all know there is very settled case law about recusals now. So the same analysis would apply. Did Joe Gonzalez come in, have any dealings with this case? I'm going to guess probably not. And so how do we screen him out if that was the issue? I don't have any concerns with the DA's office, the three attorneys who have consistently appeared, for them to continue to appear. But we can have that separate hearing if you all file your motions. Yes.
Yes, Your Honor, and we will file a motion, and I think that it's based upon Ms. Barrientos-Vela's ability to have a fair prosecution. Robert Vargas is well associated with the district attorney, and I would venture to say that the district attorney himself has been involved in negotiations or discussions about this case, and I think that Ms. McCraw would agree with that they have discussed this with the district attorney personally, and others in that office that were participating in the campaign with Mr. Vargas. So we need to have some time, I guess, to subpoena witnesses and suss that out, but that would be the basis of our motion. I know you're not going to rule on anything, of course, now, but we'd like an opportunity to brief the issue, to file the motions, and to get subpoenas. So with that in mind, if we get the motions filed by tomorrow, could we have a hearing in the near future that we can use as a subpoena date in order to get witnesses subpoenaed to appear?
Listen, I am going to conduct a thorough hearing on whatever it is you all file. But what you can't later on complain that this case has been delayed past what I have already set it for. When I specially set something, everything else goes to the wayside. So tomorrow, prime example, I have you all scheduled for the morning. I have nothing else scheduled for the morning. If we have a panel on the 30th, I've already asked for extra jurors for that day. So yes, we can conduct a thorough hearing. We can have that argument and that debate back and forth, but it's going to delay your case.
I understand.
So if you want to take some time to talk to your client today about all of that and make her election on it, we can reconvene on this tomorrow morning.
Yes, Your Honor, I understand.
I do have one. I have one question. You had mentioned the word a witness involved in this case. Are you talking about this person named Robert Vargas, whom I do not know? I've never heard of him until this incident occurred. Are you talking about Robert Vargas is a witness in my case?
No, somebody from JP2, from the constable's office, whoever was on his radio talk show on Saturday.
I see. Okay. Do you know
And
who
I
that
believe
was?
I don't know who that was. No,
Okay.
I just know there was one other person who heard that entire exchange.
Okay. Thank
And
you.
I mean, he goes on Facebook Live. I don't know if it's still on there.
Okay.
Your Honor, we would ask that, I guess it's not necessarily a protective order, but that no information be taken down that we cannot find it of any that has to do with any kind of connection between the district attorney's office and Mr. Vargas, or Mr. Vargas and any of these other witnesses, or anything where that statement may have been made, because we're trying to look for that right now. And we just don't want anybody removing photos that show connections or anything like that. So we'd ask for a protective order, at least until we can figure out what's going on with this hearing.
I mean, like Ms. McGraw said, she doesn't know Robert Vargas, so I can tell just to maintain the integrity of the process, not to destroy any evidence, but I don't have any jurisdiction over Robert Vargas whatsoever.
I
So
understand.
I can instruct the DA, but I don't know that they have any control over that either.
I understand. And just so I'm clear, because Dawn and I go back a long time, I'm not claiming that she knew this or had anything to do with it. We know that the district attorney himself and Mr. Vargas were very close. And he was an employee of Joe Gonzalez. Joe paid him for the campaign. And there are campaign finance records that reflect that close relationship that those two had with each other. And that's really what we're going to be focused on in our hearing, not the prosecutors who are involved.
And Jason, you're talking about a past relationship. You're not talking about a current one?
Well, that's what we're going to find out, I guess, in the hearing. I don't know. I don't know what the relationship is. And we need to submit all these people to have them testify about their relationship.
Okay, so we will reconvene tomorrow at 9:30. That is scheduled for in-person. We are set for pretrial motions. I am ready. I've done all my homework, but I guess we can just reconvene and see where we stand on all of this. But I didn't want to surprise you tomorrow, so I called you in today.
Thank you. Thank you, Judge.
Okay, can Ms. Vela be excused? Or do you need, I have an iPad, Jason, if you need to speak to her privately.
No, Your Honor, we'll call her on the phone and talk to her about it.
Excuse me, Your Honor. I left my phone in my office, so you can give about 30 minutes before I retrieve my cell phone.
Okay, 30 minutes.
Yes.
She needs 30 minutes to get to her phone.
That's fine. Thank you.
All right. Thank you. You're excused.
Thank you.
We're going to go off the record on this case. Here you go. Mr. Cepeda, we have your paperwork ready.
Yes, ma'am.
On Joshua,
Joshua Yanchik.
did you talk to Lay? Did you talk to the state?
Yes, ma'am.
What?
Judge, it's my understanding that he's now going to go open, plead true to the allegations and go open to you.
Okay, so I did tell Ms. Cutter I would listen to the testimony and take it in, but I may not have a decision today. But I will take the testimony. That way we're not wasting any time for the witnesses.
Judge, and I also believe that Barcena is ready for a plea.
Yes, I thought I was missing one document on her. I'll double check.
Just a heads up, Judge. Haley Martinez and Mr. Cabañas have logged back in.
Actually, on Joshua Yanchek, I think I'm missing Ashley's paperwork. Let me check. Joshua's going to plead on both, right?
Yes, ma'am. Once judgment is satisfied.
Okay, so on Joshua Yanchek, I'm missing one of the pleas. I only have the assault on a peace officer. I don't have the other case. So can you check the status of that, Gretchen?
It's me, Judge. I will, I'll send a reminder.
Travis, I have the 10427. I have that one, and I have everything else.
Okay. All right, Judge. We're not ready. Mr. Zepeda, your client still needs to sign another packet. I'm going to remind you right now. Remind him right now.
Okay, so you're gonna send it?
It's in his email.
Which one?
The second one, Josh 80
Yes,
Lee.
that one. Yeah, that one. Okay, thank you.
Raymond, I just told Ashley of the date, so you and your client are excused. Ms. Whitman or Ricardo, do you guys want to announce on your client and then I can excuse you, or what are we doing?
Judge, I know we had spoken with, I believe it was Jen. We wanted to see if we could approach you when you get a chance in chambers to discuss some matters. I don't know if we can go into a breakout room when you get an opportunity, Your Honor.
I can. Let me do the plea on Veronica Barcena, and then I can go into the breakout room.
Thank you, Judge.
And then right after, I'm going to do the hearing for Carrington. You said you had one witness, right, Joanne?
That's correct, Judge.
I'll take you up after the plea and after I have a quick conference with the attorneys on Jonathan Bettis.
Thank you, Judge.
Uh-huh.
Your Honor, I believe we've signed everything on Yanchik.
Okay, I'm gonna do one plea ahead of you, Mr. Cepeda. Thank you. He has to be sworn in too. Is Barcena sworn in? Clerks, is Barcena sworn in?
I'm about to swear him in right now, Judge.
Okay.
Ms. Barcenia, can you raise your right hand? Are you Veronica Barcenia, the defendant in this case?
Yes, Your Honor.
Are you familiar with the exhibits and stipulations attached?
Yes, Your Honor.
And do you solemnly swear it's true and correct to the best of your knowledge?
Yes, Your Honor.
You're familiar with the jury waiver?
Yes, Your Honor.
Your attorney has explained to you your constitutional rights and you understand them?
Yes, Your Honor.
It is your desire to enter this plea and waive your right to a jury trial.
I'm sorry, ma'am, I didn't hear you, but the right to waive the trial?
No, you want to take the plea and not go to trial, basically.
Okay, yes, ma'am. Yes, Your Honor. Okay, you can lower your hand. Thank you.
Let's go on the record, please. Ms. Barcena, can you see the documents on the screen?
I'm sorry, I forgot my glasses, but yes, ma'am, I can see now.
Can you see them?
Mhm.
Okay, let's go on the record. This is cost number 2021 CR 2239, the state of Texas versus Veronica Barcena. Attorneys, please make your announcements.
Gretchen Flater for the state.
Mel Dape for Veronica Barcena.
Ms. Barcena is appearing by video conference from, I'm sorry, here in the courtroom. Go ahead and tell me your full name, ma'am.
Veronica Ashley Barcena.
Okay, on the screen, I have the true bill of indictment that was filed in this case. It alleges the offense of driving while intoxicated with a child passenger under the age of 15. Do you understand the charge you have today?
Yes, yes, Your Honor.
Are we proceeding as charged?
No contest?
Hang on, hang on.
Oh,
State, are we
okay.
proceeding as charged?
Yes.
Okay, this is a state jail felony, Ms. Barcena. It has a range of punishment of anywhere from 6 months to 2 years confinement in the state jail facility of the Texas Department of Criminal Justice. It also carries a possible fine of up to $10,000. Do you understand the range of punishment that applies?
Yes, Your Honor.
You have the right to a jury trial. You have the right to cross-examine all the witnesses against you, and you have the right to remain silent. Those are your constitutional rights, Ms. Barcena. Do you understand those?
Yes, Your Honor.
When you sign this document, what you're telling me is you want to give up those rights. Is that what you intend to do?
Yes, Your Honor.
Is this your electronic signature?
Yes, Your Honor.
Are you a citizen of the United States?
Yes, ma'am. Yes, Your Honor.
If you were not, I'm still required to tell you that a plea of guilty or no contest to this charge could result in deportation, exclusion from admission to the country, or denial of naturalization under federal law. You understand that?
Yes, Your Honor.
Are you satisfied with the representation of your attorney?
Yes, Your Honor.
Mr. Aldape, does your client have a rational and factual understanding of the proceedings against her?
Yes, Your Honor.
Has she been able to assist you in the preparation of any defenses?
Yes, Your Honor.
In your opinion, is she mentally competent to waive her rights and enter into a plea?
Yes, Your Honor.
I will accept the waiver and make it part of the record. Ms. Barcena, on the screen, I have the agreement that you made. I'm going to go over it with you, and then I want you to tell me if this is your understanding of the agreement. It calls for 2 years in the state jail facility. That's going to be suspended. You're going to be placed on probation for a period of 3 years. There's a $1,000 fine. The state is going to run this concurrent with 636-460-648-591. And the state is going to dismiss a driving while license invalid case. We're going to reset this matter for a TAP evaluation. And the intention is to follow the recommendations of the TAP evaluation. 150 hours of community service. You have to do the victim impact panel live, parenting classes, and DWI intervention. Is that your understanding of the agreement that you made today?
Yes, Your Honor. Understood.
Mr. Aldape, is that your understanding?
That is, Your Honor.
And Ms. Flater, is that your understanding?
Yes, Judge.
What is your plea to the charge of driving while intoxicated with a child passenger under 15? Is it guilty, not guilty, or no contest?
No contest.
Are you pleading no contest because you have talked about this matter with your attorney and you believe it's in your best interest to do so?
Yes, Your Honor.
And are you doing this freely and voluntarily?
Yes, Your Honor.
Anyone force you to enter a plea
No, Your Honor.
or offer you anything in exchange for your plea?
No, Your Honor.
I will accept the plea of no contest. I find it's voluntarily made, and I will ask the state to tender its proof.
State offers States Exhibit 1 and its attachments.
No objection, Your Honor.
States 1 is admitted. Mr. Aldape, are you satisfied the state complied with Article 3914?
Yes, Your Honor.
Okay, Mr. Aldape, I need you to check your email and check to see if you have that discovery acknowledgement, because I don't have it. But I will, once I get it, I will sign it and make it part of the record.
I had signed it, Your Honor. I can double check. I know I signed 3 different.
I'll double check too.
Your Honor, the only issue that we have at this point, I know that the agreement said to reset for the tap. She's going to comply with whatever conditions are on the tap, but because she has a warrant on one of her misdemeanor cases, I don't want her to sit in jail. Is there a way we could proceed, waive the PSI, and with the understanding that she would have to follow the recommendations of the tap? The reason why we're asking for this is she's in the courtroom. I don't know if you saw her, Judge. She's 32 weeks pregnant. So ideally, we'd like for her to be out while she gives birth and this whole process.
What is the warrant for in the misdemeanor court?
Let's see. There's 3 misdemeanors. There's a DWI, DWLI, and a theft. I believe it's for, let me see.
It's a bond increase from May 20th.
Yeah.
But I only have one case for it.
It's just one of the misdemeanors. I don't know if Ms. Flater has any issues with her being out on bond, or if there's any issues with just proceeding to sentencing and granting the probation with the understanding that she has to follow the conditions of the tap.
Yeah, Judge, the reason that I made it a condition that it reset for the tap is because I think she needs some kind of inpatient treatment. So that's why I asked for that.
Well, no one will take her pregnant. That's the first hurdle. She's way past the time for any type of residential treatment.
When is she due?
She's 32 weeks, so I think that puts us at, I mean, I can just ask her, what is your due date, Veronica?
August 16th.
I'm gonna read the steps and then I'll come back and we can talk about it.
Yes, Your Honor. I'm sorry, Judge, I can't hear you.
And then the camera also, do you see it? Right next to it. Just hit the red slash, it'll turn green. Okay. All right. Before we go back on the record on Barcena, I was starting to tell you all that the judge of County Court 9, I tried calling her, but she didn't answer. So I'm going to talk to pretrial to see if we could do some sort of PR bond for her. I don't want her to have to go to the jail. Does she have arrangements to make bond, Jaime?
I've talked to her and I think that her funding is kind of limited. I can ask her again. Veronica, are you available to have somebody post a bond if you need to?
Not at the moment, Your Honor.
She's pretty limited with funds, Your Honor.
We are going to have to reset this for sentencing though. And it won't be until September at this rate.
The plea includes these cases that we have, the misdemeanors are going to be judgment satisfied. So I'd hate for her to sit in jail for a case that would have been judgment satisfied immediately.
Right. I'm trying to not send her to jail. I'm trying to get her a bond that she can make. But sentencing with me though, she does have to come back because if she requires some sort of residential treatment, I need to be able to make a decision on that. So.
Just a thought, Judge, is it possible to sentence her today and knowing that because she's pregnant, she wouldn't even be admitted into a program because of that? Could that
I'm not
be
going to sentence her without the TAP. I have tried that in the past. It just gets very messy. People don't show up for the TAP. They don't show up to court. I have to chase them. We had a young lady today that we've been chasing for at least over a year. And I don't like to chase anyone. So
as far as Ms. Barcena, she knew she had a warrant today and still showed up though.
I know, but I still want to see her back for sentencing. So I am going to say sentencing is September the 9th. Ashley, let's make that the next PSI date, please. September 9th. Send it over. Tell her to come interview her.
Yes.
Okay, so we're gonna wait for pretrial services. Let's go back on the record, David, please. I do find the evidence is sufficient to substantiate your guilt. I will make no other findings at this time. I'm gonna wait until we come back for sentencing September the 9th. And I want a TAP done. Let's do a PSI while we're at it. Jaime, what I'm gonna do is pretrial services is gonna come down here and interview her. Does she have to make the trip? Look at the time. The time to the jail. I'm gonna try to see if satellite can wait for her. If not, she'll make the trip, but at least she'll go with all the bond paperwork. Okay.
So she should be able to get out tonight, Your Honor.
Yeah, I'll call the magistrate right away.
Okay, if you need anything on my end, let me know. I'm here, Judge.
Yes, thank you. For now, I'm gonna put her in a breakout room with probation.
Maybe excuse Your Honor.
Yes, thank you.
Thank you.
Ashley, if you could put Barcena in a breakout room. Oh,
Can you check and see if Gretchen has done the plea paperwork on Mr. Tejas?
You told me to wait, so I haven't done anything. I'll do it right now.
Oh, I'm glad I came back. Yes, do it.
Okay.
Right, I did tell her to wait.
Let's get ready to go on the record on Joshua Yanchek. Yes, ma'am.
What you can see.
Right, and then she has, can they do satellite or not? So we're trying to avoid. Has Joshua Yanchek been sworn in?
I'm about to, Judge.
Okay, go
Mr.
ahead.
Yanchek?
We'll talk to the clerk.
Hi, sir. I'm gonna go ahead and swear you in, okay? Can you raise your right hand for me?
Raise your right hand.
Are you Joshua Yanchek, the defendant in this case?
Yeah,
Are you familiar with the exhibits and stipulations attached?
Are you familiar with the stipulations and paperwork?
oh yeah, yeah.
Okay, keep your right hand up for me, please.
Right.
What's that?
I'm sorry?
Are you familiar with the exhibits and stipulations attached, sir?
Yes.
Okay, can you keep your right hand up for me, please?
Keep your right hand up. That's all she said. Thanks, yeah.
Oh, what's that for?
So you're swearing. You're swearing in. She's swearing you have to keep your right hand up.
Oh, all right.
You swear the same are true and correct to the best of your knowledge, so help you God?
Yeah, I'm not religious. I don't want God to help me. I'm not religious at all. I'm not. But I got my right hand up.
Okay, you swear?
Yeah, I swear to tell the truth.
Are you familiar with the jury waiver?
Yeah,
And your attorney has explained to you your constitutional rights and you understand them?
yeah,
And it is your desire to enter this plea and waive your right to a jury trial?
yeah.
Okay, you can put your hand down.
And Your Honor, did you want us to approach in a breakout?
Yes, I'm moving you guys now.
Okay.
Number 9. I'll be right back.
I've been here since 9:30. Waiting.
Yes, but she's trying to get at this other lady some help.
Oh, okay.
You can put your hand down there. So you caught that thing, huh? Pretty good.
Yeah, I seen it coming. I was like,
Pretty good.
and that was maybe like 10 years ago. I still got the shirt. I cut the sleeves off and made it like a work shirt.
Yeah.
But I want to go to another Spurs game.
Yeah.
It was fun.
Yeah, they're a lot of fun, especially when we win.
Yeah. You know, we got the besides what's that team?
What is this supposed to be?
to October 4th. Ashley, on Jonathan Bettis, reset to October 4th.
Yes, ma'am.
I don't have a motion to withdraw on George Caldera. I'd like to let Ms. Chalkowski go if she's still on. Ashley.
She checked into another court. I'll walk it out to you right now, Judge.
Okay, walk it out, and then you could just message her that she's excused. She doesn't have to come back. Mr. Caldera, did you hire somebody?
Yes, ma'am, I actually did. They were supposed to send the paperwork today. It's Miss Paula Perez.
Okay, what I'll do is I'm gonna give you a reset.
Okay.
Until
Yes, ma'am. She had a court in Atascosa, so she wasn't sure if she was gonna be able to make it.
No problem. I'm gonna give you a reset until October the 4th.
Yes, ma'am. Thank you.
Okay, so you're not gonna get anything from me today with that date, but that's the date I'm giving you. So you're expected to be back with your attorney, okay?
Okay, I'll let her know. Thank you,
All
ma'am.
right, thank you. So we're gonna do the plea on Joshua Yanchik. We're gonna do the hearing on Carrington after that. And I don't have any other pleas so far.
Your Honor, Ed Garza, could I approach?
Yes, sir.
I have Adriana Campillo.
Yes.
And I guess we're gonna maintain staying on the trial docket. We've been given an offer, I've conveyed it, and she's declined it. And so I guess we're going to need a jury trial on this matter.
Okay. Ed, I'm gonna set you for September the 13th. We have a panel that week.
September 13th.
Yes, sir.
Yes, ma'am.
Okay, thank you. You both are excused.
Judge, and just briefly, Your Honor, I do want to get on the record. The state had offered to essentially proceed on Ms. Campillo's case on a lesser included offense. And because the defense has rejected that offer, Judge, I'd like to get on the record that the state is revoking that offer and will not put that offer back on the table anymore.
Okay, well, that's understood. Thank you.
I understand that too, Judge.
Okay, thank you, Ed. Good to see you. Take care.
I'm good to see you too. Have a happy 4th of July weekend.
Oh, you too.
No drinking and driving now.
No, nobody. No. Tell my court reporter that way.
I know.
Tell him.
Thank you, Judge. Have a good,
You're welcome.
good afternoon. Thank you.
On Donna Alice, Mr. Basile, what is the status of Donna and Valadez Rolando?
Judge, I'm starting the paperwork on that. I just got an email from Gretchen to do the paperwork.
On which one?
Correct, Your Honor. On Alice?
On which one? On Donna Alice?
That's correct, Your Honor.
Okay, and then the other one, Valadez?
I'm sorry, I was just getting a snack before you on. Hold on.
Okay, take your time.
I talked to my client. I relayed the offer. I discussed the videos he wants to look at. One specific video. I haven't had a chance to set it up. I had a PO had to work on the 4th court. I think that will decide whether he wants to make a counter and take the offer or not.
So you need some time for discovery?
Just a few weeks, Your Honor. There's enough time to have him come in and look at the video. If Gretchen is still willing to take a counter, I've chatted with her, but I haven't heard back.
Let's do July. Can you do it by July 12th? Because if not, I have to put you all the way in September.
Can we do on July 13th? I already have another case for you to call in court on Steve Montalong on 13th.
Yeah, we can do it on July 13th.
That way I could probably do it both same time. I can meet with both of them next week because my federal sentencing next week and my trials were cleared out. So yeah, I can do that.
Okay.
Just look at the video. So.
All right, thank you.
That would be
and so then Mr. Valadez is excused. You can go, sir. Your next court date is July 13th. You'll get another Zoom invite, okay? Thank you. And then Donna Ellis is a plea. What about Abram Nanez?
That's not my case.
Abram Nanez is Fernando Trevino.
Hello.
Yes, Fernando, what is the status of your case?
Hold on, give me a sec. Let me get the volume up. My client was released on the 9th of last month. The last few times we've been here, he's been incarcerated, so I just assumed they're going to be bringing him on the Zoom at the jail. I tried the bail bonds company. They gave me a number, and the only thing I get is a message saying, "Hi, this is Weta. I don't want to talk to anybody right now, so call me later or leave a message." So
I feel your pain. Okay, so I'll issue a judge's warrant, Fernando.
okay.
Okay,
And
thank you.
I wanted a moment. I know I spoke to you yesterday. I wanted to talk to a prosecutor about a bond.
Yes.
Who would I speak to on that?
What kind of case is it?
It's a drug case.
Yeah, one of the CTD, Travis or Luis, whoever's not doing the Yanchik plea.
Okay.
I can talk to him, Judge.
Okay, thank you.
I believe that Haley Martinez signed on, Judge, also.
That's right, Judge. I'm having an announcement on Haley Martinez.
Oh, I had already issued a warrant for her. Okay, so what happened?
Nothing, Judge. We logged off, and then Ashley notified me that Ms. Martinez logged on a little bit later than the docket call, but she is present. I did confirm with the state. They've tendered an offer, and I need a reset to communicate with Ms. Martinez regarding that offer.
Where is she right now?
She should be on the screen,
Oh, I
Judge. Ms.
see you.
Martinez.
Okay, Ms. Martinez, unmute yourself. I had already issued a warrant for your arrest because you didn't show up to the Zoom, but, and neither of your attorneys had contact with you. So this is your going I'm going to withdraw the warrant. Don't interrupt me. Hang on, don't interrupt me. I'm going to withdraw the warrants this one time only, but it's your responsibility to be in court when you have to be in court. So let's do August the August the 16th, please. Oh, wait, Ashley, is that one the one you said was really full? Yeah, let's do August 24th then. August 23rd. August 23rd, that's a Monday, that's the call, that's the trial docket day.
The 23rd, Judge, we could squeeze it on the 16th if you like.
No, we have a lot on the 16th already. Let's do the 23rd.
Yes, ma'am.
Okay, thank you. You're all excused now.
Thank you.
Thank you, Judge.
You're welcome. Mr. Yanchik? Hi, can you unmute yourself?
Please turn it with me,
Hey, Mr. Yanchik, I just want to thank you for your patience today.
I've been here since 9 this morning.
I know. I know.
I missed work, but that's fine.
Okay, well, thank you for missing work and thank you for being here. And you know, I've been working since 8:32. I've been talking to a lot of jurors. I've been doing pleas all day, so
yeah,
we're both in the same spot.
You still got a lot more. You still got a lot more to go.
I sure do. So thank you for understanding and thank you for your patience. But I'm ready to go on the record, David, please. Did the competency evaluation get resolved?
Yes, Your Honor.
Okay, thank you. Okay, let's go on the record. This is cause number 2020 CR 10426 and 10427, the state of Texas versus Joshua Janchik. Attorneys, please make your announcements for the record.
Travis Rodriguez for the state of Texas.
Rodolfo Cepeda for Mr. Yanchik.
Mr. Yanchik is appearing by video conference in his attorney's office. Mr. Yanchik, tell me your full name for the record.
My full name is Joshua Lee Yanchek. Yanchek.
Do you see the document I have on the screen?
We don't see a document, right?
Oh, I've had a long day. I forget to screen share. Go ahead. Do you see it now?
Yeah, I see it. I see it there.
Okay, so let's go over this indictment. It alleges three counts of evading arrest or detention, second offense. Actually, it's just two, Vasquez and Thompson, count 1 and count 2. How are we proceeding, state?
Yes, Judge. We are proceeding on count 2 of the indictment. Therefore, we move to waive and abandon count 1 of the indictment.
Okay, and then in cause number ending in 10426, this is count 1 and count 2, evading arrest or detention, second, alleging Vasquez and Thompson again. Looks like Thompson is 3776, June 29, 2018. Yeah, that has to be an error.
Yes.
That is right.
So both of these indictments allege the very same offense with M. Thompson, number 3776 for the same offense date. So he's in count 2 of this indictment, the 426, and he's in count 2 of, oh, I'm sorry, hang on. Is that my bad?
It's the same indictment, Your Honor.
Oh, yeah, I take that back. Let me pull up 07. Man, I almost got Travis. You should have seen his face.
I didn't think there were, I thought there was only one count in the, yeah, aha.
All right, so this, Mr. Yanchik, I have on the screen the second indictment, and that is in cause number ending in 427 for assault on a peace officer. So do you understand the two different indictments that you have? You have one indictment for alleging an assault on a peace officer and one indictment alleging evading arrest of a peace officer.
I understand. I understand, Miss Lady.
Okay, thank you. We're going to go over the range of punishment for each of these cases. In the first one, in the 0427, that's the assault on a peace officer. That's a second-degree felony. So a second-degree felony is punishable by confinement in the Texas Department of Criminal Justice Institutional Division for any period from 2 to 20 years confinement. It also carries a possible fine of up to $10,000. Do you understand that?
Yes, Miss Lady, I understand it fully. I do.
Okay. And what I need you to understand also, Mr. Yanchik, is that in this case, you have the right to a jury trial. You have the right to cross-examine all the witnesses against you, and you have the right to remain silent. Those are your constitutional rights. Do you understand those?
Yes.
When you sign this document, what you're telling me is you want to give up those rights. Is that what you intend to do?
Yes.
Okay, let's move on to the evading arrest second offense. That's a state jail felony. So the first time that you run away from an officer, it's a misdemeanor, and then the second time that you run away from them, it's a felony. Well, no, is that right?
Can I ask a quick question, Miss Lady? To the understanding, evading arrest is over a quarter mile. Am I correct?
I don't know the answer to that.
No,
I don't know the answer to that, sir. But did you run away from them?
You can run away on foot, that's way, you can also do it on a vehicle, that's different.
All right.
Yeah, it's the second offense is a state jail felony. So do you understand that, Mr. Yanchik?
I understand, Miss Lady.
Okay, so a state jail felony has a different range of punishment, not like the second degree felony. It's just confinement in the state jail facility, any period from 6 months to 2 years confinement. It also carries a possible fine of up to $10,000. Do you understand that range of punishment?
Yes, I do.
Okay, you also, in this case, Mr. Yanchik, you have a right to a jury trial. You have the right to cross-examine all the witnesses against you, and you have the right to remain silent. Those are your constitutional rights. Do you understand those?
Yes.
Mr. Yanchik, do you see this signature, this electronic signature that I have here on the screen?
Yeah, that's my signature right there.
Okay, that's what I was going to ask. What about in this other page? Is this your electronic signature here?
Yeah, every signature that I received, that's mine.
Okay.
I just put my initials because sometimes it just takes too long to.
Okay. Yeah, I agree with you. So, Mr. Yanchik, in both of these cases, when you sign it, you're telling me you want to give up your constitutional rights. In both of these cases, is that what you intend to do?
Yes, ma'am.
Okay. Are you a citizen of the United States?
I am. I was born in Portland, Oregon.
Okay. Well, I have to ask every single person I see the same question. So if you were not a citizen, I'm still required to tell you that a plea of guilty or no contest to this charge could result in deportation, exclusion from admission to the country, or denial of naturalization under federal law. Mr. Yanchik, are you satisfied with the representation of your attorney?
Yes.
You shook your head no, though. Did you mean to shake your head no?
No.
Okay, so you are satisfied with Mr. Cepeda?
To a certain extent.
He's a great lawyer.
How you know?
Oh, I've known him for years.
Yeah,
we used to be neighbors at the Milam building.
Yeah, he's been doing me good.
Good.
He's been, I give him a thumbs up.
Very good. So, Mr. Cepeda, does your client have a rational and factual understanding of the proceedings against him?
Yes, ma'am, he does.
Has he been able to assist you in the preparation of any defenses?
Yes, ma'am.
In your opinion, is he mentally competent to waive his rights and enter into a plea?
He understands everything, Your Honor.
I will accept the waiver of rights and make it part of the record. Mr. Yanchik, we're going to go over your plea bargain because you made a plea bargain on these cases, and I want to go over it with you. And then I want you to I want you to tell me that that is your understanding of what you agreed to. So let's start with the case on the assault of a peace officer. The recommendation is for 4 years TDC. The state will remain silent on your application for deferred. They are recommending regular community supervision. There's a $1,000 fine. The state is going to dismiss the 2 resisting arrest cases. We're going to do a TAP evaluation, 150 hours of community service, and an evaluation of your mental health, and then a moral recognition therapy class. Is that your understanding of the agreement you made in the assault case?
Miss Lady, I see right now, I wasn't explained to 4 years of TDC.
No.
I was it.
Yes, that's punishment.
Okay, so let me explain how that works.
Okay, please.
The state is saying that you should be convicted of this crime, and they recommend you be placed on probation. So you still have to have a legal sentence, and the legal sentence would be 4 years PDC. But we don't send you to prison if I grant probation. You stay on probation. That's the only reason it's there, because that is the legal sentence in your case. Now, if I grant deferred, which is a different type of probation where I wouldn't find you guilty, then I could do as much as 10 years on the deferred. I usually don't hit 10. It has to be like, more of the violent offenses that I do the 10 on. But
Right.
that is the agreement that the paperwork says. Is that your understanding of the agreement?
Yes, ma'am.
Okay.
I just have a really quick question, if you can take my question, Miss Lady.
Yes.
Is there any possible way? I know the stipulation of I have to do 150 hours of community service. No problem. I'm not a lazy guy, but I drive an 18-wheeler and I'm out of state kind of like all the time. Is there any possible way I can reverse that and like do like a counseling and show proof that I'm getting counseling instead of the community service? Is because, I'm an over the road driver. I'm an owner operator, and I'm always like tonight I have to go over there to Mansfield, Louisiana. As soon as I leave here, I'm going to Louisiana. Is there any way I can not do the community service? And if I can just get some counseling, I have insurance. And I really want to talk to a counselor every month and try to get my mind clear.
Yeah, absolutely. We could definitely work that out. I like to usually let people focus on one of the most important things of probation, which is counseling. So we'll talk about that. But for now, I do need to take.
That's all I want to do is talk to somebody.
Okay, so I'm going to ask you for a plea on the assault of the peace officer. Are you going to plead guilty, not guilty, or no contest?
I'm gonna do the no contest.
Okay, are you pleading no contest because you've talked about this matter with your attorney and you believe it's in your best interest to do so?
I believe so.
And has anyone forced you to enter a plea today?
Not my lawyer. No.
Has anyone offered you anything in exchange for your plea?
They haven't.
Okay. I will accept your plea of no contest. I think it's voluntarily made, and I will ask the state to tender its proof.
State offers in evidence State's Exhibit 1 and all of its attachments, pending any objections.
No objections, Your Honor.
State's 1 is admitted. And Mr. Yanchik, in cause number 10426 on the evading arrest second offense, what is your plea to that case? Is it guilty, not guilty, or no contest?
No contest, Miss Lady.
And are you pleading no contest in that case because you have talked about this with your attorney and you believe it is in the best interest to do so?
Yes, ma'am, it's in my best interest to do so.
Okay, and same question, anyone force you to enter a plea on that case?
Nobody's done nothing.
Okay, or offered you anything in exchange for your plea?
I don't want it. Nobody has made no deal with me or anything.
Okay, I will accept your plea of no contest on the evading arrest. I find the plea is voluntarily made, and I will ask the state to tender its proof.
State offers in evidence State's Exhibit 1 and all of its attachments, pending any objections.
No objections, Your Honor.
Okay, State's 1 is admitted. Mr. Cepeda, are you satisfied the state complied with Article 3914?
Yes, ma'am.
I will sign the discovery acknowledgement and make it part of the record. Mr. Yanchik, do you work out of state a lot?
You really, I do, but since I'm gonna be on probation, I need to know. I have a hazmat driver's license, every endorsement. I don't know how it's gonna work. But yeah, I usually go to Louisiana, back and forth, Houston, back and forth. That's what I do is drive. I got a CDL. I've been having it since 2014.
Judge.
Okay. Yes, sir.
Judge, I don't mean to interrupt. On the state jail, the terms are a little bit different. I don't know if you went over them, but what we're trying to accomplish is just a straight conviction, judgment satisfied, get in, get out.
Yeah. Yes. I'm sorry. I forgot to do that. Let's, Mr. Yanchik, I did take your plea on the evading arrest And I'm now looking at the paperwork. It looks like the punishment agreement there is 1 day in the Bexar County Jail, and that case will be satisfied, so it'll be closed out. Is that what your understanding of the plea bargain was?
Yes, ma'am, but will I have to go book myself in today?
You're not gonna get booked at all. You're going to just be satisfied on that case, okay?
1 day?
1 day, you're done. I'm gonna satisfy it today. Okay, so give me just a few minutes so I can read all the evidence and I'll be right back.
All right. It's a man spill. I go to the northeast. Yeah, it's up by Shreveport. Yeah. So I go to Houston, pick up a load, and then come back. I'll be back by Saturday. It pays $1,000. Be careful.
Ashley, John Young back from the breakout room. I think we've signed all the paperwork.
It's something about me. I like driving in the rain. I like driving my motorcycle for some reason. Oh yeah, that's a good movie to watch, Biker Boys. Okay. Lawrence Fishburne's in it. I like it. He's like one of the top dogs. He's called the King of Cali. He's had a nice Hayabusa. And his son is coming up, starting his own gang, and they're clashing against each other. So he wants to take the title of King of Cali against his dad. So his dad lets him win. I've been seeing a lot of the ATVs out lately and the motorbikes, the dirt bikes. Mm-hmm. A lot of people are out riding in the streets now. Mm-hmm. I like good. And I'm up for that. You ever rode a motorcycle? Mm-hmm. Me and my buddy, we went to Austin one time, some years back, and I can remember.
John, I just sent you a reminder on the discovery, but I have your client's paperwork.
Are you saying I haven't signed the discovery acknowledgement yet?
Correct.
Let me go look. Hey, Barb.
Mr. Basile, Miss Ellis has paperwork that needs to be signed. Do you need a breakout room?
I'm going through the discovery and stuff I need to sign. I'll be sending it back in just a minute. And I can do it all at one time. Okay?
I'm ready to go back on the record. State, can you tell me a little bit about your silent on deferred? Can you tell me about his criminal history?
Travis, I have it. Do you want me to tell her?
There's a history, Your Honor. Notably, he has been on deferred before and revoked and placed on straight supervision. So,
does he have any penitentiary trips for any violent offenses?
No. None.
No, Judge.
Mr. Yanchik, why didn't you just let the officer handcuff you?
Let me explain this to you the best way I can, Miss Lady. I've been having the same issue. I've had charges with this same, I've had charges with this same cop lady. Back in 2012, they was dismissed. This lady was not a cop at the time. She was a code compliance. I'm trying to make them understand about the time frames and the situations about actually what had happened. It's just an ongoing, these cops aren't even on the force anymore. The Wilson cop, not on the force anymore. The Johnson lady, she's still a code compliance. I didn't want to get in handcuffs. It's because I was talking to Vasquez. Me and Vasquez have a personal relationship. Over the years, I've been in Kirby since 1989. He was talking to me. Hey, what's going on, Joshua? And then I didn't want to get in handcuffs because I know that's my red button. When I get in handcuffs, I just lose it. Like, I don't know why I didn't get put in handcuffs. Like, they know I'm not going to get detained for nothing.
Do you understand that I can't have the behavior repeated? You can't do that because you're going to land in front of me again. I would like for you to succeed at deferred.
I know I want to succeed at deferred because I have no felonies in the last 8 years. I have a very, very good job, 2 or 3, 4,000 a week. Like, I've got a family, my girls, they know, they see me trying every time and then get the red button. Let me tell you this too, Miss Lady.
No, let's move along because I'm ready. I'm gonna put you on deferred today. If that doesn't work out, you're gonna have to see me again. I don't want to have to see you again because you have violated. Okay, well, then we're on the same page.
I know.
So let's start with the cause number ending in 10426. I do find the evidence is sufficient to substantiate your guilt. I will find you guilty of the offense of evading arrest, second offense. And I will sentence you to 1 day confinement in the Bexar County Jail. You get credit for the time you have served on that case, and I do find the judgment is satisfied. Mr. Yanchik, this is a plea bargain that you made on this case. I did follow the plea bargain agreement, so you do not have a right to appeal. Ashley, all the documents have the exact same cause number, so you guys are gonna have to fix that. Let's move on to cause number 10427. I do find the evidence is sufficient to substantiate your guilt. I will make no other findings at this time. I'm going to grant the application for deferred for a period of 4 years, $1,000 fine. The state is going to dismiss 632-655 and 632-656. The 150 hours of community service are held in abeyance. I want you to focus on the MIG-MYOF evaluation. You're also going to do a course for moral recognition therapy. Mr. Yanchik, I want you to see a probation officer in person once a week until you have been evaluated for MIC-MIOF. So for now, let's get a high-risk officer face-to-face every week. This is a plea bargain case as well. I did follow the plea bargain agreement. You do not have a right to appeal. Mr. Yanchik, again, I want to thank you for your patience. We're not done yet. You still have to go into a breakout room and you have to talk to my probation officer, and then you will be excused, okay? Yes?
Yes.
All right, thank you. We're off the record on this case. I need to correct all that, please.
Yeah, they don't even have their paperwork right.
Ashley, please put them in a breakout room. Let's go on the record on Carrington.
Gretchen is on her way, Judge. I'll go to room 6.
There you go. That's take that to the clerk's, please. Ms. Eagle, are you ready on your motion?
Yes, Judge, I'm ready. If my witness is still there, I'm ready, Judge.
Where was your witness?
He's on the screen, Michael De La Fuente, Judge.
Okay, yeah, he's there. And then after that, we'll do Mr. Marganowitz. Gretchen, did you hear that Barsana walked out? Nice. Eyes are okay, let's go on the record. You ready, David? This is cause number 2021 CR 2588B as in boy, the state of Texas versus Natalie Carrington. Attorneys, please make your announcements for the record.
Joanne Akel for the respondent, Judge, and I having a hard time hearing Gretchen.
Is your microphone on? No, not that one. No, not that one. The Zoom mic. She needs a Zoom mic. Can you hear her now?
Can you hear me
Joanne?
now? Yes, I can hear her, Judge.
Okay, perfect. Ms. Carrington is appearing by video conference from the Bexar County Jail. Go ahead and unmute yourself, Ms. Carrington, and tell me your full name. You called the jail and asked them to help her unmute herself.
Natalie Nicole Carrington.
Okay, thank you.
You're
We're
welcome.
here on the application for writ of habeas corpus seeking bond reduction filed by the defense. Ms. Eagle, this is your hearing. Can you call your first witness?
Yes, Judge. I'd like to call Michael De La Fuente, please.
Okay, Mr. De La Fuente, can you please raise your right hand?
Yes, ma'am.
Do you solemnly swear or affirm the testimony you're about to give in this cause shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Go ahead, Ms. Eagle.
Thank you. Will you state your name for the court reporter, please?
My name is Michael Ramirez de la Fuente.
And do you know Natalie Carrington, Mr. De La Fuente?
Yes, ma'am.
How do you know her?
She's my granddaughter.
How old is Natalie?
She's 18 and a half.
And when she came into custody in March of 2021, was she pregnant?
Yes, ma'am.
And did she have that child?
Yes, ma'am. She had a beautiful little boy.
And how many, when she had that child, how many children did she have?
She had a daughter, one daughter already.
Right. So, and how old is her daughter?
Her daughter is 15 months.
Has Natalie lived in Bexar County, or let me ask you this, how long has Natalie lived in Bexar County?
All her life.
Do you know what the bond amount is that is currently set for Natalie for this case number?
Yes, ma'am. They told us 500,000.
Can Natalie make this kind of bond?
No, ma'am, not at all.
Does Natalie have any savings accounts?
No,
Does she have any bank accounts of any type?
no,
Can she borrow any money from a bank or lending institution to make a bond like this?
no, ma'am.
Does she own any land?
No, ma'am.
Does she own a car?
No, ma'am.
Does she have any assets that she could sell to raise money for this bond?
No, ma'am.
Can she borrow any money from friends or relatives to make this bond?
No, ma'am.
Are you and her other family members trying to raise money to make her bond?
Yes, ma'am. We've been trying since March.
All right. Did you all have an unexpected expense that came up in May of this year?
Yes, ma'am, we did.
And what happened?
Excuse me, just 1 minute. My her son passed away in May of this year, and we had to use some of the money that we were saving for her for his burial and cemetery, the plot.
All right. And how much money does the family have currently to put towards her bond?
Well, after that we paid for the funeral, and that we have like 7,000 left.
All right. And has the family sold any assets that they had to try to raise this money?
All we have is one vehicle, and no, ma'am, but we've had benefits.
Okay. Does the family have the ability to borrow any money from the bank to raise a $500,000 bond?
No, ma'am.
Do you have any friends or other family members that can help you raise a bond for a $500,000 amount?
No, ma'am.
Have you attempted to make the $500,000 bond?
Well, like I said, we've been trying to make some money, but we can't raise that much money. There's no way.
Okay, did you contact some bonding companies?
Yes, ma'am.
Okay, and after you contacted the bonding monies, what did you learn about how much it would cost to post a $500,000 bond?
It would cost us 50,000 to post a $500,000 bond.
What amount of bond do you believe the family can make for Natalie?
Well, with what we have, I'm saying 70,000.
Are you asking the court to reduce Natalie's bond to this amount?
Yes, ma'am, I am.
All right, I'll pass a witness at this time, Judge.
I have no questions.
Any other witnesses that you have, Ms. Eagle?
Judge, I have no other witnesses. I would only like the court to take judicial notice of the bond that was reduced in a co-defendant's case, 2021 CR 2588C. That bond was reduced from 500,000 to 50,000.
Yes, and on that case, the court didn't take any evidence. That was an agreed amount. Do you have any witnesses state?
The state would just have some exhibits, no live witnesses.
Okay, go ahead.
Judge, the state would like to offer State's Exhibit 1, the prosecution guide that was created in this case.
Any objection to States 1?
Judge, for purposes of this hearing, we have no objection.
The state would also offer State's Exhibit 2, the NCIC, TCIC records for this defendant.
Additionally, for purposes of this hearing, we don't have an objection to State's Exhibit 2.
And we would also offer State's Exhibit 3, 2 pages that are printed out from the defendant's cell phone records.
And Judge, we object to that because on the face of it, it doesn't show that it was my client's cell phone record or that the things that were printed out on there that my client actually did. So we would object to that at this time.
That objection is sustained. Is that all the exhibits?
I have State's Exhibit 2, Judge.
Can I ask, Mr. De La Fuente, did you say that her son passed away
Yes, ma'am, in May.
of this year
Yes.
Yes, ma'am.
while she's been in custody?
Yes.
Yes, ma'am. I love you, Natalie.
Mr. De La Fuente, this is court. You can't do that.
I'm sorry.
I understand you, but there's still an appropriate way to behave in court.
Yes, ma'am, I'm sorry.
While I'm reading this, can you tell me her role in this capital murder?
Yes, Judge. This defendant was a friend of the victim who set the victim up to be robbed. She was at the victim's home, allowed the shooter and several other individuals into the home. There's also evidence that this defendant, which was in the cell phone records, was communicating and with the individuals who committed that actually killed the victim. And this defendant was texting or was searching how to kill someone quickly on her cell phone. So that's the evidence that the state intends to show. Also, in regards to defense counsel's argument about a co-defendant, that co-defendant was the driver who was the least culpable in the state's opinion, the very least culpable person involved in this 6th defendant capital murder.
What is her relationship to Kyle Phillips, Miss Eagle?
I don't believe she has any relationship with him, Judge.
Okay. Is there a decision on whether this is a death case or not?
Yes, Judge, the DA has decided that we are not going to be seeking the death penalty on this defendant.
I'll hear argument if you all are ready.
I'm ready, Judge, if the court is ready.
Yes, go ahead, Ms. Eagle.
Judge, I would just ask the court to consider reducing my client's bond. She's 18 years old. You just heard testimony that while she was in jail, she had a child in this year, and the child passed away in May while she was in custody. The prosecution guide indicates, Judge, that my client was a friend of the deceased victim. She had no part in letting anybody into the house or any part of the murder. She had spent the night at the victim's house and was a good friend of hers and had lived with the victim previously. She was not the driver in this case. She's not the alleged shooter. And her culpability in this case, I think, is very slight. Ask the court to, considering her age and the circumstances of her current life, if the court would consider reducing her bond at this time.
State.
Judge, I would disagree with defense counsel's assessment that she is not very culpable. The night before, she was communicating with individuals about robbing the victim and was searching how to kill someone quickly. So I believe that she is one of the more culpable individuals in this case. She knew the victim. She set the victim up. Additionally, Judge, she does have criminal history. It's juvenile criminal history based on her age. She hasn't had very much time to be an adult, but it's not only history, but it's also violent assaultive history. This defendant is charged with a very serious capital murder. The facts are that afterwards she got into the vehicle with all of the individuals involved and went to another location with them. And Judge, this is a very serious violent offense. And I believe that you reviewed in the prosecution guide that the victim's two children that were very young were left in the home with their dead mother, and were only found because the victim's boyfriend happened to come home because he couldn't get in touch with her. And those children were left in the home with their dead mother. It's a very serious case. It's a very serious offense, and the bond should not be lowered. If it is lowered, Judge, I would ask that she be placed on full house arrest and be placed at least on full house arrest and no contact with any of the co-defendants or the victim's family.
No, put your hand down, Ms. Carrington. Your lawyer didn't call you, so we're not going to hear from you today. But I want you to listen to me. Look at me when I'm talking to you, please. This group of people, whether you knew them or not, knew them a little bit or a lot, these group of people are very dangerous people. So how have you liked being in the jail? Is this the longest you've ever been in jail?
Yes, this is my first time in adult jail.
And how is it?
I don't like it.
Which part don't you like?
Being without my daughter.
Yeah, you feel the void, right?
Yes.
You think about her every day?
Yes, ma'am.
Were you away from your daughter the day that Jasmine was murdered?
Yes, ma'am.
Okay, Ms. Carrington, what I'm going to do is I'm going to grant the application for writ of habeas corpus. I'm going to grant the bond reduction. I'm going to reduce it to $150,000. I'm going to order GPS full. I'm going to refer you to the special needs unit of the pretrial services office. GPS full, I will waive the fees on that. No contact with all of the co-defendants. It's not what you asked for, but it is a reduction. I'm very concerned about what happened to Jasmine Williams. And the who did what is going to be flushed out in trial. I get that. But at the very minimum, we know for a fact you were there. You were in the house when somebody was murdered. So that does concern me a lot. So I will grant the reduction like I have indicated.
Judge, can you also make no contact with the victim's family? She knows them.
Okay, yes, no contact with the family of Jasmine Williams.
And Judge, will the court consider allowing her to work? She has a job, I believe, waiting for her.
Not right away, Ms. Eagle. I really want her to get screened with the special needs unit. I have a feeling they will refer her for some, either like the Roars outpatient program. I really would like for her to start getting some services. She's been through a lot, clearly. She's gonna need some help if she gets out. That's the order of the court. We're gonna go off the record. Thank you. You're all excused.
Thank you, Judge.
Part of my stack of work to do.
I'm done.
How many witnesses do you have, Ms. Cutter? Yeah, let's do that next then. Okay, we're gonna go on the record on, that's from the morning. On Tucker Margazanitz. This is cause number 2018 CR 13395. The state of Texas versus Tucker Margazanowitz. Attorneys, please make your announcements for the record.
Gretchen Plater for the state. Good afternoon, Your Honor. Lee Cutter for Tucker Margozowitz. And just for purposes of the record, his name has been misspelled on his criminal file. That's why it's a little wonky.
I need the file for Margaz. I need the file for the MCR. I'm sorry, David. I think I was muted when I called the case, but I called the case. Did you hear me? Yes, Carrington is done. After this hearing, I will take the plea of Richard Thayes and Donna Ellis in that order. That's how they came in. As soon as I get the file for Mr. Margosonitz, I will. Do you have the allegations, Gretchen?
Yes,
Is it a lot?
yes. I think that he's pleading true to all of them.
Yeah.
Are you gonna resubmit these that you wanted? Oh, yeah. Great.
Ashley, is the paperwork complete on Mr. Taz?
I think it is, Mr. Young.
My life is complete.
Yes. I don't know. I think it was like SIDS. I don't think they know.
Okay, we're back on the record on 2018 CR 13395. For purposes of the record, Mr. Margosonitz is present in person. Can you tell me your full name for the record, please?
Dr. Addison Margosowitz.
Margosowitz. Can you hear him, David? Yes, okay. So I have the motion to revoke your community supervision filed by the state. It alleges 7 violations. Is it your intention to plead true to all of those, Ms. Cutter?
Yes, Your Honor.
Okay, so I will enter a plea of true to all of the violations. This is an open plea to the court for punishment purposes. Probation, can I have the report of the drug court referral? Thank you. So call your first witness, Ms. Tucker.
Thank you, Your Honor. I call Jason Wagner, please.
Cutter. I switched it around. Go ahead, come on up, sir. You see those microphones?
Yes, ma'am.
You will actually be speaking into both of those, okay?
Okay.
Can you raise your right hand? Do you solemnly swear or affirm the testimony you're about to give in this cause shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Go ahead, Ms. Cutter.
Thank you, Your Honor. Sir, please state your full name and your occupation.
Jason Frederick Wagner, recovery coach with Lifetime Recovery.
Okay, and what do you do as a recovery coach, sir?
I help, I myself am in long-term recovery for 17 years. And I help the individuals when they're leaving Lifetime find their own recovery pathway and help them with resources to further their own recovery.
And do you know Tucker Margosowitz?
Yes, I do.
Okay, and tell the court to what extent you know Tucker.
I knew Tucker when he first came to Lifetime Recovery, and I began formally recovery coaching him on September 21st of 2020.
And are you familiar with the allegations against Tucker? Or he's already pled true. He's admitted that he has lapsed in his recovery. Are you aware of that?
I am now, yes.
Okay. And were you aware he was admitted into the drug court, or he's been screened and accepted?
I am now, yes.
Okay. And do you have any familiarity with Judge Glenn or the drug court at all?
Yes, at a foreign job, and we get clients from federal drug court right now. I know Judge Glenn. So yes, we get clients from federal drug court with Judge Glenn.
Okay. And do you have an opinion as to whether or not Tucker could be successful in his recovery if this judge were to allow him to participate in drug court?
I think when I knew Tucker before, I teach a class strategies for recovery. And at the time that Tucker was there, he always seemed to have a willingness for his recovery then. I didn't, so I think he would, could be successful.
Okay, are there any other supports or concerns you would have if this judge were to allow him to participate in that drug court and remain on probation?
I don't have any concerns, no.
Okay, do you have an opinion as to where he should live?
I think he would be work best because he does well in a very structured environment. And one structured environment that I know of is Pay It Forward Ministries. It's their program called The Next Right Step. And it is they're very, very structured. It is a 12-step oriented program, but it's very, very structured. And I think he would be very suited there at that program.
Is that like a halfway house or what is that?
No, it's a sober living environment, and it's very structured, and they can go out and work and they come back, and it's very structured.
Okay. And do you have any idea if he would qualify to attend that or who sponsors that?
It's put on by Pay It Forward Ministries.
And it's located near Haven for Hope. Correct?
Yeah, it's on the campus of Haven. It's not run by Haven. It's run by Pay It Forward Ministries.
Okay.
I refer a lot of people to them.
And would you be willing to continue coaching Tucker in his recovery if this court were to allow him to participate in the drug court?
Oh, yeah. I coached them for a year, and I started coaching them on September 21st of 2020. And I coached them for a year. So yes, I'm still coaching him, just we have not been in contact. So I guess I'm still willing to coach Tucker.
And when you did interact with him, was he compliant with you, polite, appropriate?
Yes, yes.
And you really specialize, it seems like, in recovery. Is there anything else you think this judge should know before she makes a decision as to whether or not to allow Tucker to participate and frankly give him another chance in a felony drug court scenario?
Okay, can you repeat that? Is there?
I did not ask it very well. Yes, I will. Is there anything else that you believe this court should know as far as his likelihood for success or participation or anything like that if she were to allow him to go into the drug court?
I just think that Tucker, the time that I did work with him, he just had a strong willingness back then. And I think that he still has that willingness now. It's just we had lost contact, and I think we could still continue to work well together.
And you may have said this, so I apologize if you did. He completed inpatient at Lifetime last year, correct?
Yes, I was not his counselor. I'm the recovery coach, because recovery is something different when you leave. I talked to them when they were getting ready to leave and start their recovery, but he did complete, yes.
Probation has recommended that he go to a jail or a prison setting rehab facility. In your experience, if someone's already completed the Lifetime inpatient, does it make sense to have them go back again, or would he be better suited in the recovery phase in transitioning?
Personally, I don't agree with them going back to a jail setting because you're doing it again. You're doing treatment twice. So I think it's better for them to go on to work a recovery program. I don't see what is the point of going from treatment to jail treatment. So I think it's better to go from treatment into a recovery setting. So.
And are you willing to be supportive with Tucker if he were in there with Judge Glenn in his recovery and to ensure that he complies with all of the rules of probation?
Yes, yeah, because I still am his recovery coach. So absolutely.
Thank you. I pass the witness.
Judge, did you know that Mr. Margozowitz has already had the opportunity to go through drug court?
No.
Okay, does that change your opinion at all?
No.
Okay, did you know that the resources of drug court are extremely limited?
No, but I know resources. That's part of a recovery coach, a resource broker.
Okay, and so someone who has already had this opportunity and then reoffends and reoffends and reoffends and reoffends and reoffends. So when is that supposed to end?
I don't understand your question.
Okay. You are at Lifetime Recovery. Can you tell the judge all of the times that Tucker has participated in programs with Lifetime Recovery?
I know that he was there twice. I don't have his file, but I know that he was there twice, and there was a medical issue that he had to leave, and then he came back, and then he came again. I don't have his file. I just have my file as a recovery coach
Why don't you have his file?
because I'm not his counselor.
Okay, and do you not have access to his file?
No, the quality control counselor is here. So
So
that's a question to ask him.
Him. Okay,
So
all right. And so you became his coach September 21st of 2020, correct?
Correct.
And then did you know that he was, had already relapsed when you became his recovery coach?
I didn't hear anything about a relapse.
Okay, so you didn't know that August 12th, 2020, he tested positive for Xanax?
Inside Lifetime?
No, with probation.
No, because he was in Lifetime at that time.
Okay, so I'm sorry, he didn't test positive. He admitted to using it on that date. So he's at Lifetime using Xanax. Did you know that?
I don't recall hearing anything about that.
Okay, and that he failed to submit to drug testing October 19th, 2020, and October 27th, 2020, and November 6th, 2020.
And
So those are times that he's in Lifetime Recovery, correct?
I guess so.
Okay. I guess you just really don't know when he was in Lifetime Recovery.
No, I know when he's in Lifetime Recovery, but what does that have to do with somebody's recovery? I mean, what does that have to do with somebody's willingness?
I didn't ask you about his willingness. I'm asking you, did you know that he failed to submit? I guess that would be not willing, failing to submit to urinalysis when he was supposed to.
Failing to submit to a urine analysis. I don't understand what your question is.
Okay. Did you know that Mr. Margozowitz was on probation out of this court?
Yeah, I knew he was on probation.
Okay. Did you know that one of the conditions of probation is that he give regular urinalysis when he's asked to?
No, I don't know. I'm not his counselor. I'm a recovery coach. I don't read the conditions of his probation.
Okay. Judge, I pass this witness.
Anything else from Mr. Wagner?
Very, very briefly, Your Honor. Lifetime's inpatient is 30 days, correct?
No, it is 90 days,
90 days.
45 to 90 days.
Okay. And you're not sure about the dates as to when he was there. You just know he was there last year. Is that fair to say?
Correct. Yeah, I'm not the counselor.
And
I'm there to talk to them when they're getting ready to leave.
And would you agree with me that even when someone completes rehab, that they can still relapse, that addiction is an ongoing challenge?
Yes.
And in your experience, you think that he can be successful based on your interactions with him, if he's given the right supports, and it sounds like you're willing to help broker whatever he needs to have him be successful. Is that fair to say?
Absolutely.
Okay, thank you, sir.
I have no questions, Judge.
Can you step down?
Yes, Your Honor. And thank you, sir, for being here this morning.
Thank you.
You can step down, Mr. Wagner. Thank you. Call your next witness.
Raleigh Rollins.
Rollins.
Yes, Your Honor.
Really well, thank you. Next hand, do you solemnly swear or affirm the testimony you're about to give in this cause shall be the truth, the whole truth, and nothing but the truth. So help you God.
I do.
Very well. You may proceed, Ms. Cutter.
Thank you. Sir, please state your name and occupation for the record.
My name is Raleigh Rollins. I'm Quality Assurance Manager at Lifetime Recovery here in San Antonio.
And Mr. Rollins, my office subpoenaed you, asking you to bring Tucker Margozowitz's records, correct?
Yes,
Okay, and just given the time, and thank you for being here this morning. Sir, did Mr. Margozowitz attend Lifetime Recovery last year?
he did.
And I'm sorry, I'm a little hard of hearing, a little louder.
He did, yes.
Okay. And do you know why he left the first time?
It was for medical reasons.
Okay.
Yes, he was, it was a medical discharge.
For scabies, correct?
Yes,
Okay. And did he successfully complete inpatient recovery with Lifetime?
he did on his third admission.
Okay, and the second admission, that one also ended in a medical discharge, is that
It was a
correct?
medical discharge, yes.
Okay. And both of those medical discharges were for scabies, correct?
One scabies, one, I believe, yes. Yeah.
Okay. And do your records show if on August 12th of 2020, he was if it was inpatient at Lifetime?
On August the 12th,
Yes, sir.
I have the records for 3 admissions here. Okay. His one that he successfully completed, he was admitted on August the 20th. And he discharged on October the 5th. On one, he was admitted on
What year are you talking about?
2020.
2020, okay.
2020. On one, he was admitted on June 18th, 2020. And he was discharged on June 22nd, 2020. And on one, he was admitted on May 4th, 2020, and he was discharged on May 22nd, 2020.
Okay, and those first 2 were medical, correct?
Yes,
And I believe you said he started that 90-day program, or about 90 days, give or take, August 20th of last year?
yes,
Okay. So when he admitted to using Xanax on August 12th, he was not in recovery at that time, correct?
I can only go by what the records say. Yeah, and so
And you've never met? Tucker?
I've never met Mr. Margo.
I have no further questions for this witness, Your Honor.
Has he been in Lifetime Recovery other than in 2020?
Not that I'm aware of, no.
Your Honor, may I approach the witness?
Yes, ma'am.
I'm going to show you what's been marked. You recognize this?
It's a Lifetime Recovery Completion Certificate in the 28th day of July 2018 by Mr. James Saxton.
Do you know who James Saxton is?
I do.
And so is this a certificate that your Lifetime Recovery creates?
Yes.
Your Honor, I would like to offer State's Exhibit 1 into evidence and bring to opposing counsel for any objections.
I have no objection, Your Honor.
States when it's admitted.
So you don't have his records from when he was involved in Lifetime Recovery back in 2018?
No, ma'am.
Okay. I pass the witness, Judge.
Can you step down?
Yes, Your Honor.
Step down, sir. Thank you.
And with the court's permission, I'd ask that they be released.
Mhm. Yes. Call your next witness.
Your Honor, I would call Tucker Margozowitz.
Okay, he can testify from there if you can just kind of put the microphone in the middle.
Yes, ma'am.
you raise your right hand? Do you solemnly swear or affirm the testimony you're about to give in this cause shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
You may proceed, Ms. Cutter.
Thank you, Judge. Mr. Margozowitz, how long have you been in county jail?
Going on 4.5 months.
Okay, and what, have you done anything to better yourself or to continue in your sobriety while you've been at the jail?
Yes, ma'am. I got a recovery emotion, which is twice a week, 2 hours each class, and AA meetings as well, which I have the sheets for and the certificate for finishing the class. And as well, I'm staying in the class to receive the second certificate. And I'm also a kitchen trustee on the breakfast cook in the Phoenix.
Okay, and tell the judge how old you are, sir.
33.
And Tucker, do you have any college education?
Yes, ma'am, I do. I went to the University of Mississippi and then transferred to ACC and then eventually transferred to Texas State in Marcus.
And what is your drug of choice, sir?
It's heroin.
And there were some questions about you being in drug court before. You've never been in felony drug court, have you?
No, ma'am. I was screened and I would go for the pre-screenings on Thursdays, but when I actually went to court for the charge that they were sending the drug court on, it got dismissed. And I don't know if there was a mix-up. My probation officer brought up the fact that she thought that I just stopped going, but my case was dismissed. And I was told I didn't need to go to that.
But you were never formally in drug, you've never been in drug court before, you've just been screened, correct?
No.
And you have been into, I mean, you've been to rehab more than once, haven't you?
Yes.
Okay.
I went the time in 2018. I went as soon as I got bonded out on this charge, and went to stay in sober living house and immediately leaving there 1 month after my arrest, checked myself into rehab. I had to wait in that sober living house for a month until I actually got a bed at lifetime. That's what I mean. So that's the time of 2018.
And you have, your court summary says you hadn't been to safety yet, but you have, correct?
I've been to what's called CRTC in the 38th Judicial District in Uvalde. It's a state jail and facility, 6 months.
Okay. And you realize that this court gave you a really great deal when she allowed you to come out and granted you shock probation, correct?
Yes, I do.
And you realize that you messed that up.
I did. I have no excuses. I have no excuses. I'm sorry for making my stay late. I'm sorry for everything I've done. I know it was such a huge opportunity for me. And if there's anything I've learned in these 4.5 months I've been here, it's just what I've done with myself is, I don't have words. I have no excuse to possibly say I'm sorry. From the bottom of my heart, I know that both of you all have given me huge opportunities. And plus, and there's no excuse for it. I take full responsibility, and I'm just hoping you can see that I'm trying. I struggle with addiction. I'm not a bad person. Since April 2nd of 2018, I have not committed any new crimes. I struggle with addiction, and I have a problem we have, and I feel like something like drug court where it's a straight structured environment. I just, apologize for messing.
Mr. Margozowitz, since you've been a cook trustee at the jail, you've actually applied to and been accepted to St. Philip's College, correct?
Yes, to the culinary school.
So if this court were to allow you out, you would start school in August, is that correct?
Yes, ma'am.
And you've also been accepted into New Choices Intensive Outpatient Program, correct?
Yes, which is a 4-night a week outpatient.
Okay. And you're in agreement that you would live at a sober house? I mean, that's run by Haven for Hope?
Definitely.
But you are committed to your recovery, is that correct?
Yes, ma'am.
Just one second, Your Honor. I'm sorry. I didn't have any exhibit stickers. Mr. Margosas, I'm going to show you, or actually, Your Honor, I've shown defense exhibits 1, 2, and 3 to the state. I don't believe there's an objection. Defense 1 is a letter from New Choices Treatment Centers indicating that they do have a spot for Mr. Margosowitz in their intensive outpatient. Defense exhibit 2 is his completion from the jail for the first track on substance abuse, and defense exhibit 3 is his AANA log while he's been in custody as well. Alongside those people.
Any objections?
None from the state judge.
Okay, they're admitted.
And Tucker, if the judge were to allow you to go to felony drug court, would you agree to wearing a drug patch that will indicate if you have any usage at all?
Yes, ma'am.
And you realize that that holds you 100% accountable. It's not just a random UA. It will track your drug use if you ingest anything.
Yes, ma'am.
And in fact, if she were to allow you to do that, you're asking that she put that on you to help ensure that you are successful on probation.
Yes, and if I do that, I would ask this, I get put on immediately coming out of here.
I pass the witness.
Any questions, State?
Yes, Judge. So you were in prison for 6 months after you pled guilty out of the 399, and you got 4 years TDC from Judge Castro, correct?
Yes, ma'am.
And so what did you do while you were in prison?
I was a commissary trustee and I would attend church on Wednesdays and Sundays.
Did you do any of the drug treatment in prison?
No.
Why not?
Because they wouldn't let me on a 4-year sentence to attend changes, which is their drug treatment class. You have to be at least 2 years out from your release date.
And so it wasn't long enough.
No, ma'am.
What about AANA? They have that in prison, correct?
Yes, ma'am.
Did you participate in that?
I tried, I put in I-60s for it and I never heard back. They were too full with the unit I was at. I was in Lopez in Edinburgh.
And this judge, you asked for shock probation after Judge Castro sent you to prison, and she granted that shock probation, correct? And she put you on 0 tolerance, correct? So can you tell us when the first time was that you used drugs after she released you from prison?
It was around August 10th. And I talked to my probation officer and I requested, because at the time for being medically released, I was just told just to do the outpatient, be on house arrest. And I used, and I was upfront with her and honest, and I asked if I could go back to lifetime to the inpatient. And she told me that if I could get myself back in there within a week, telling her that I could, as opposed to going back in incarceration.
Okay, and so then you went to lifetime, you were medically discharged several times, but you did get actually to go to the program, and you went from August 20th to October 5th, correct?
Yes, ma'am.
So then on October 27th, 2020, you tampered with your urinalysis test, and I'm assuming that you used a Wizinator, is that right?
I just had a bottle of fake pee.
Okay, a bottle of fake pee, and why was that?
I was dirty.
Okay, and what did you use that time?
It was heroin.
You used heroin. When did you use heroin?
It had to have been starting the week prior to that because I had clean UA before that. And at that point, the dirty UAs that came after that point, or the missed UAs, were I'd already had a judge's warrant out for my rest of that.
So the November 4th, the reason that you for November, you didn't report because you had an open warrant.
Not me, it was a judge's order. Is what it was called. Yes, ma'am.
Okay, and so you didn't want to go back into custody, you didn't want to go to treatment, and so that's why you didn't show up for that date?
I wouldn't, well, this time had an ankle monitor on and paying it for the time until I was picked up.
Pass the witness, Judge.
Anything else?
Tucker, you realize you almost have a calendar year of days credit in custody, right? And frankly, if this judge were just to order you back, you would be very close to your mandatory release date. You would just be out on parole. You're aware of that, right? And knowing all of that, you're still asking that she give you the chance to continue in your recovery and participate in drug court.
I don't want to go back to prison. I'm sure y'all are aware of what it's like. I mean, have to work, it's not a fun place. And, you know, they're going back to a place like that, there is no recovery, there is no treatment. It's do your time and get out, come back out to what, to nothing. So it's, if I had a choice to be able to go to something that would help me, I would much rather that than just go back with the wolves and come back out to no structured environment at all.
And you're taking care of your grandmother up until you were picked up, correct?
Yes, ma'am, I was.
How old is she?
She was 93. She passed away just a month ago.
She passed away while you were in custody, correct?
Yes, ma'am.
And it was her intention to come testify to this court as well. Is that true?
Yes, ma'am. Yes.
Okay. And your mother's here and she'd like to talk, but given the time, yeah, I think you've kind of said your piece. Is that fair to say?
Yes, it is.
Okay. I have no further questions.
Nothing more, Judge.
Do you both rest?
I believe that the state does have a witness, Francesca Garcia. I think she was able to zoom in. I don't know. Is she here? Yeah,
Is
there.
Francesca Garcia on Zoom? Okay, great. So let's swear you in. You raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this cause shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do, Your Honor.
Go ahead, State.
Thank you, Judge. Would you introduce yourself to the judge?
Hi, I'm Officer Francesca Garcia from Adult Probation. I was Mr. Margozowitz's probation officer on regular probation, and now I'm actually in the specialty unit court for felony drug court.
And I know that the defendant said that he was screened for drug court before. Do you have any additional information about that?
He was screened for drug court. I was looking at the outcome of drug court. So basically it's whatever is the outcome of the hearing. Since he was not given probation, then we didn't accept his case. So he was screened and we were able to qualify him, but he wasn't on probation. So we couldn't accept him at that time.
And that was for the 2016 CR 9693W, correct?
Yes, ma'am.
And it looks like he pled to 6 months instead of going to drug court.
Correct.
Okay. So he had the opportunity and he passed up that opportunity.
Yes, he did.
And do you have, as somebody that is a participant in drug court, do you have a position as to whether or not you believe that this defendant should go to drug court?
I believe as Mr. Margozowitz's case, I was actually the clerk in drug court when he was going through the process in 2016. So I am familiar with him. So when I did get him for probation for this charge, he was supposed to go to SafeP and got out of going to SafeP. I felt like that was not the right thing for him because I knew that this would eventually happen. He needs a structure and he was given that chance. And he didn't take that chance back then either.
Do you have anything else you'd like to tell the judge?
I do. Judge, like I said, I am in felony drug court and I am the officer. His case has already been staffed with drug court. And yes, we were willing to take his case, but I do want to let the court know that it's not going to be for outpatient. We agreed as a drug court team that he needs to go to SafeP followed by felony drug court supervision if he were to get a chance at probation again. So and drug court is a very intense program. It is there so he can be in recovery for a lifetime. So I don't know if Mr. Margozowitz knows that, because I did hear that he was saying that he has a bed here and a bed there, and that has always been the case while he's been on probation with me, to get out of going into a lockdown facility and what is recommended for him from a treatment standpoint, and he gets out of it every time. So at this point, I feel like we should give that opportunity to someone else if he's not willing to participate in the drug court program that we have for him.
Thank you. I pass the witness.
Any questions of this witness?
Yes, Your Honor. Good afternoon, officer. Were you aware that he had actually been to a lockdown facility for 6 months for treatment in Uvalde?
No, we don't have access to that. That was probably prior to him being on regular probation here in Bexar County.
Right, so he was at the CRTC in Uvalde, the state jail facility, for 6 months, but none of your records have that, right?
We don't have that, no.
Okay. And you've mentioned several times he got out of going to SafeP. Well, you're aware that he couldn't go because of the COVID-19 pandemic, right?
He could go. I had a few defendants that went during COVID.
Well, I mean, while he was at the prison, he couldn't go because of the pandemic. Were you aware of that?
I was aware that he was transferred back to Bexar County, so he was on the list to go when I got him.
Okay. But you wanted him, or I guess he's been fully accepted to the drug court program with Judge Glenn, right?
He has qualified. He's not accepted yet.
And there's no wait list at this time, correct? He could start in the next few days, potentially?
There is a wait list, but we are willing to accept him tomorrow, but he will be going to SafeP.
Right, what I'm saying, is there a wait for SafeP right now?
About a month wait for SafeP.
And you're also aware that he has recently just completed an inpatient rehab, right?
And no, I was not aware of that. Oh, are you talking about Lifetime?
Yes, last fall.
I was the officer of record when he was at Lifetime, and he relapsed shortly after.
And you mentioned that he passed up going to drug court in 2016. Do you recall that?
Yes.
But you weren't privy to what the deal was or why he pled to 6 months or anything else, right? You just know that it was a possibility, but he ended up being sentenced to 6 months.
Right. So
Right.
he could have done drug court if he wanted to.
And you heard the other recovery coach's testimony that he didn't believe it was advantageous that he go to another inpatient rehab, that the issue was him transitioning from that and the supports he needed to do that.
I was not on when you had a recovery coach on. Was it a recovery coach or was it?
Yes.
Oh, yeah, recovery coach is different than our drug court staff.
Okay, I've passed the witness.
No more questions, Judge.
They should be excused.
Yes, Judge.
Thank you, Ms. Garcia. You are excused. In fact, hang tight, please. Don't go anywhere. Anything else, State?
I have no more witnesses, just argument, Judge.
Okay, go ahead on arguments. Ms. Cutter, this is your motion.
Thank you, Your Honor. We respectfully ask that you allow Mr. Margozowitz to continue on probation. And I think he's definitely taken ownership for his mistakes. And I believe I heard the court last time we were here say you remembered granting him a shot probation, and that was a huge gift, and he relapsed. But unfortunately, what he said, I believe, is true. Unfortunately, there's not this system, the support systems in place in the prison system. They're just not. Tucker didn't commit a new crime. He didn't pick up a violent offense. He's an addict. He's an addict and he's addicted to, I would argue, probably the most addictive substance there is, heroin. I can tell you in my 6 or 7 years maybe now of knowing Tucker, this is the first time he's actually had a plan. He's got a college that's accepted him and something that he's actually enjoying. And ironically, it's something that he learned while he was in Bexar County Jail. And he realized, hey, I have a passion for this. I'd really like to go forward on it. And I do believe, and in talking with the recovery coach and hearing their testimony, that he does okay and he does fine when he goes to inpatient. It's that transition period where he struggles. And putting him in a place like Haven for Hope, or it's called Pay It Forward Ministries, but it's on the same campus. And he has to be there every night. He's not at home with mom or with his girlfriend or anything else. And he does have all that accountability and he's got something to look forward to. I think that will help in his recovery and would be rehabilitative to him and to others. His grandmother that he helped care for, unfortunately passed away a month ago while I was on maternity leave and he was waiting to come here and see this court. And like I said, if I know the state's asking to send him for 4 years, he's almost done the amount of time he would need to do to be released mandatorily. And then I feel like he would really just be lost to the system. I don't believe that SafeP makes the most sense right now. Again, he would be an automatic release again after that, just based on the sentence time. I think if we really want to rehab him, he's got a good plan that's very tangible to do that. And so we would respectfully ask the court to allow him to participate as such. I realize that's a big ask, but he has come humbly. He's admitted his mistakes. He was forthcoming with his probation officer and said, I need help. I need to go back. And it takes a big person to do that. So we are asking that you allow him to continue on probation and that he go transition into the drug program or go through that structured living facility and be allowed to attend classes. And I have proof of that admission for the court as well, if you'd like to see it. Thank you.
State.
Judge, I think that we have reached the end of the road with Mr. Margozowitz. You know, he has been in the system over and over. You know, Judge Castro sent him to prison. You gave him another chance. You gave him a second chance to get out of prison where he really doesn't want to be. And he takes your chance and he continues to use. And then he goes to lifetime recovery for what I guess is the 4th time. I know that he wasn't there very long in June and he was there for like 20 days in May. But he completed that program and the first thing he did was go out and use again. I think that the resources of our county are better used on someone else. And so Judge, the state believes that he should just finish his prison sentence and then he can go back to lifetime recovery or these other programs that he's gotten involved in when he gets out of prison.
Mr. Margozowitz, if I thought something different other than you are an addict, you would have already been in prison. You know that. And when I granted shock, I was very clear that I was going to be zero tolerance as to your treatment structure. And even after everything fell apart, I simply amended your conditions and asked that you surrender so that you could go to SafeP. That's all. And then when you didn't do that, I said, okay, show up at a compliance hearing. I said it earlier this afternoon, I don't like to chase people for anything. We expend resources doing that. When I say show up and surrender, I mean show up and surrender. When I say show up to court, I mean show up to court. And possibly if you're going through an episode where you are using drugs, it doesn't mean much to you. But I agree with felony drug court, and I'm going to refer you to felony drug court, but I'm going to order today that you go to SafeP. I know that felony drug court can supervise you after SafeP, provide transitional housing and everything that you need. I can do that today. or I can just revoke your probation. But I mean, I want to know from you that sending you to SafeP is going to be something that is going to be helpful in your life. If you're just going to waste that opportunity, then we could just send you to prison today.
With the drug court, I definitely think that it would help.
You'll be supervised by drug court. You will be in their program after SafeP. I'm gonna take a break. I'm gonna give you a chance to talk to your attorney. I'm going to take one plea so that we can keep moving these cases along. You can take the plea from there, Gretchen. I'm ready on Trevino. David, do you need a break real quick? Yeah, okay. We're gonna take a 10-minute break so David can get a break for his hands. And then we'll go on the record with, I'm sorry, Tellez, Richard Tellez will be first, and then Donna Ellis. Thank you for your patience.
So you don't mean Trevino? Okay, that's fine.
So Richard Tellez will be first, and then Donna Ellis. Those are the last two cases I have, right?
Yeah, but, well, I guess I can get a hold of Gretchen afterwards. She looks like she's busy. That's why I couldn't do this hearing.
Okay, well, hang on. She'll call you.
Okay, I appreciate it. I'm gonna go ahead and get off the Zoom. Have a great
Can you hear me?
rest of the day, or evening.
You too.
Bye.
Mr. Theos, can you hear me?
Yes.
Hi, yes, I'm gonna go ahead and swear you in. Can you raise your right hand for me? Are you Richard Theos, the defendant in this case?
Yes.
Are you familiar with the exhibits and stipulations attached?
Yes.
You swear or affirm the same are true and correct to the best of your knowledge?
Yes.
Are you familiar with the jury waiver?
Yes.
And your attorney has explained to you your constitutional rights and you understand them?
Yes.
And it is your desire to enter this plea and waive your right to a jury trial?
Yes.
Okay, thank you. You can put your hand down.
You referenced in your motion, but it wasn't attached. That's why. That's a great. Yeah.
Bianca, it's not letting me open up my packet. I'm not sure if she's applying. I don't remember. Ask Gretchen, she said no.
Hey, Travis.
Yeah, what's up?
Travis, the judge said that you can do these, please, so I'm gonna take off. Is that okay?
Absolutely.
And she's gonna let you finish Margozowitz.
Okay.
It's done, so
Yeah.
it's
That's
just sitting
fine.
here. Okay, thank you.
No problem. Thank you.
Travis?
Yeah.
I've got the, I think you know this already, but I have the Ellis, I'll take care of the Ellis plea, Donna Ellis.
Awesome.
Which I think is last. Is that cool?
Travis, are you doing Tejas?
I am. I'll at least appear on the record. Sounds like all the paperwork's already done, right?
Yeah. It's only taken 6 or 8 hours or 3 days.
The wheels of justice.
I don't know. I think it's more like the square wheels of justice.
Richard Ellis. So on this one,
Real easy. 6 months.
okay, so it's charged as a felon. It's charged as a 3rd degree, but we're going to plea it as an attempted, therefore making it a state jail, 1244, 180 days.
And in all honesty, I don't believe it's 1244. I think it's 180 days.
I was a state jail. Okay, very good.
I would have loved for you to say that. If you decide to do it, I've done my due diligence. You're welcome to undercut Gretchen any way you want.
Hey, that's well, she's not here, so okay, no.
This is the last I'll say about that. I love Gretchen like a sister. But I wouldn't want to be on the wrong side of her.
I forgot that they closed the door at 6. So yesterday when we worked late, I was like, the door's not working. And the cleaning lady's like, it's loud. I could go around.
We're doing the side.
Right, so the side doors, it's fine. It is leads me right to the garage anyway. Yeah. But probably today you'll have to walk me after all the craziness.
But I saw back here.
You requested a record. You requested a record.
Yeah, I saw back here. But you know what? He did the same thing as the insurance officer.
Yeah.
Says, oh yeah.
Yeah, let's start with this. Start to your, I think I saw some already, but they should have the right to. They should have a right to ask that you review this sometime. We can have. And I spoke to them this morning, they sent me a last. The law several times to another equal case.
Judge, I'm ready to go.
Hello?
So they're gonna do one other case before they do yours, so just wait there, okay?
Is the TV unmuted? Ready, Dave?
Yeah.
Okay. Let's go on the record, please, on Richard Reyes. This is cause number 2020 CR 6315. The state of Texas versus Richard Reyes. Attorneys, please make your announcements for the record.
Travis Rodriguez from the state of Texas.
John Young for the defense.
Mr. Reyes is appearing by video conference from the Bexar County Jail. Can you please state your full name for the record?
Richard Christopher Thayes.
Okay. Mr. Reyes, on the screen, I have the true bill of indictment that was filed in your case. It alleges the offense of felon in possession of a firearm. Do you understand the charge that you have this afternoon?
Yes, Your Honor.
That is a third-degree felony. It is punishable by confinement in the Texas Department of Criminal. Oh,
We do have
is
a
there a
motion.
motion?
Yes, Judge. The state moves to proceed on the lesser included offense of attempted felon in possession, therefore reducing this to a state jail felony.
No objection.
That is granted. A state jail felony is punishable by confinement in the state jail facility for any period from 6 months to 2 years confinement. It also carries a possible fine of up to $10,000. Do you understand the range of punishment, Mr. Reyes?
Yes, Your Honor.
You have the right to a jury trial. You have the right to cross-examine the witnesses against you, and you have the right to remain silent. Those are your constitutional rights. Do you understand those?
Yes, Your Honor.
When you sign the document, this one that I have on the screen called the court admonishments, what you're telling me is you want to give up those rights. Is that what you intend to do?
Yes, Your Honor.
Mr. Reyes, is this your electronic signature?
Yes, Your Honor.
Are you a citizen of the United States?
Yes.
If you were not a citizen, I'm still required to tell you. A plea of guilty or no contest to this charge could result in deportation, exclusion from admission to the country, or denial of naturalization under federal law. Mr. Reyes, are you satisfied with the representation of Mr. Young?
Yes.
Mr. Young, does your client have a rational and factual understanding of the proceedings against him?
He does, Your Honor.
Has he been able to assist you in the preparation of any defenses?
He has.
In your opinion, is he mentally competent to waive his rights and enter into a plea?
I believe he is.
I will accept the waiver and make it part of the record. Mr. Reyes, let's go over the plea bargain that you made in this case. It calls for the prosecution to proceed on the lesser included attempted felon in possession of a firearm. Punishment will be 180 days in the state jail facility. No fine and no applications for probation. This will run concurrent with 635636. Is that your understanding of the agreement?
Yes, Your Honor.
Young, is that your understanding?
Yes, Your Honor.
And Mr. Rodriguez, is that your understanding?
One caveat, Your Honor. Unfortunately, the case cited in concurrent with, I believe it should be 635-635.
Yes, that's what it is.
And that's a case, it's a misdemeanor out of County Court 13. On behalf of the state, I apologize to defense, to the court, and to the clerk, but that for that error, but that should be changed to reflect the correct cause number. All of that
Okay.
said, Your Honor, that is the state's understanding.
Okay. What is your plea to the charge of attempted felon in possession of a firearm, a state jail felony? Is it guilty, not guilty, or no contest?
No contest.
And are you pleading no contest because you've talked about this matter with your attorney and you believe it's in your best interest to do so?
Yes, Your Honor.
And are you doing this freely and voluntarily?
Yes.
Anyone force you to enter a plea today
No.
or offer you anything in exchange for your plea?
No.
I will accept the plea of no contest. I find the plea is voluntarily made and ask the state to tender its proof.
State offers into evidence State's Exhibit 1 and all of its attachments pending any objections.
No objection.
States 1 is admitted. Mr. Young, are you satisfied the state complied with Article 3914 in this case?
I am, Your Honor.
Yes?
Yes.
Okay, thank you. I'll sign the acknowledgement, the discovery acknowledgement, and make it part of the record. Thank you for your patience. I know you guys have been very patient. I just need to read the evidence and I'll come back on. Are you guys ready? Yes. Okay, I'll take it up afterwards. Let's go back on the record, please. I do find the evidence is sufficient to substantiate your guilt. I will find you guilty of the state jail felony offense of attempted possession of a felon in possession of a firearm. I will assess punishment at 180 days confinement in the state jail facility. You do get credit for the time you have been in custody on this case. This will run concurrent with 635-635. That's a misdemeanor case. This is a plea bargain case. I did follow your plea bargain agreement, Mr. Thayes. You do not have a right to appeal. Do you understand?
Yes, ma'am.
And just so we're clear, the state law on felons in possession of firearms is after 5 years from your release in prison prison, you are allowed to have it in your home under Texas law, but under federal law, it's a lifetime ban. So and there's actually some federal law that says that if you have different parts of a firearm, even though they're just different parts not put together in your car, that could be a violation of federal law as well. Just putting it out there. I took a firearms course and it got drilled in there. All right,
Ghost guns.
yeah. All righty, so we are off the record, and if you have no other holds, you'll be remanded to the custody of the sheriff to begin that sentence.
Hey, I'll
Thank you,
try
Mr.
and get you in 13 as quickly as I can.
Thank you, Mr. Young. We got it done.
Thank you.
And I heard you say Monday, Tuesday, Wednesday, and I'm sorry. You know, I tried to take care of you same day, so, but we did it. Thank you.
I know. It's been, and I had to leave that Monday. I just had to.
Yeah, I will never, ever hold that against you. Trust me.
Well, what you don't realize is I'm in the middle of cancer treatment, and I was supposed to go for blood work and my next injection. So
I didn't know that.
Yep.
You look great.
I'm old and tired.
I'm sorry. All right. Well, thank you for hanging in there with us today, John. I appreciate it. Okay, let's go back on the record with Mark Gozowitz. And then we're going to do Miss Donna Ellis, who has also been very patient, and her attorney have been very patient. I should start to have some like some prizes, right, for people who are patient at the end of the day. See, look at David. He's about to say something smart. See, like I already know his facial gesture. Go ahead, David. We're almost done, David. We're almost done.
And it's almost after dinner. Oh, perfect.
It is. It is almost time for dinner. Okay, so let's go back on the record on 2018 CR 13395. Ms. Cutter, what did your client decide he wants to do?
Your Honor, I did talk with Mr. Margozowitz at length, especially after hearing testimony from the drug court officer. And we believe, and he believes that it's in his best interest at this time to finish his sentence at TDC and then hopefully transition into school. He was sentenced to 4 years. We would humbly ask this court consider giving him 2 years because he's not going to take up a bed or treatment for anyone else at this time. And that would allow him the ability to go, like I said, to school. It won't be this fall, obviously, but a little sooner rather than later. He's got a lot of life ahead of him. And the other thing we would respectfully ask for is that the judgment be amended to reflect the time he's been in county waiting for this. He was set, and my baby came 7 weeks early back in March. And it hasn't been his fault by any means that he's waited this long. So we would ask that the court allow him credit for that.
Okay. I do find that violation of condition number 2 is true, that on August 12, 2020, you illegally admitted use of a controlled substance, that was Xanax. I find violation of condition number 2 that on October 19th, 2020, you failed to submit to drug testing. I find it's true violation of condition number 2 that on October 27th, 2020, you failed to submit for drug testing. I also find violation of condition number 2 that on November 6th, 2020, you failed to submit to drug testing. Violation of condition number 5, I do find it is true that you failed to report for the month of November 2020. Violation of condition number 17, that on November 4th, 2020, you violated the terms of your zero tolerance. And on October 27th, 2020, you failed to comply with zero tolerance by tampering with the UA. Having found that those violations are true, I'm not going to reform your judgment that a sentence is appropriate. So I find that they are true. I will grant the state's motion to revoke the community supervision. and I will sentence you to 4 years confinement in the Texas Department of Criminal Justice Institutional Division. You get credit for all the time you have served. Can you, Valerie, give me an idea of how many days that is?
So far, in total for this case, he has 192 days.
Does that sound about right?
Yeah, yes, Judge, that doesn't include the time that he was in TDC, but that's his Bear County time. Yes.
Yes, so he also gets credit. The judgment has to be very clear that he had almost 6 months TDC time that he needs to be given credit for, Valerie. So maybe you can make a note.
And I have those exact dates if you'd like. me
Yes,
to
if
get
you
with
can
them.
give them to my clerk, that'd be great.
Yes, ma'am.
Please, thank you.
This is a plea bargain case. I did follow your plea bargain agreement, so you do not have a right to appeal. Ms. Cutter, I don't have a trial court cert, but we have the forms here. If you don't mind, take some time, fill it out, and I'll sign it.
Yes, Judge. And is that correct since it was an open plea? I'm sorry, I haven't done one in a really long time.
You're right. David, we're not off the record yet. So this is a revocation of your community supervision. You have a limited right to appeal. Okay, we're gonna go off the record. She needs a trial court cert form. Can you give it to her, please? And then we're gonna do the last plea for today. Yeah. Oh, they're at the entrance? They're not here?
They're over there.
Oh, sorry, Lay. Tried to help you. Alice, you ready? You're muted. Can you unmute yourself? Ms. Garcia, you're free to go. We revoked and he's gonna go to TDC. Thank you. If you can update it on your side.
Thank you. Have a good day, Judge.
Yes, ma'am, you too. Mr. Thayes, you're excused also. You can go back. You're excused. All right, so the best for the last, Mr. Basile.
I see she's got a painting with her behind her. Yeah.
Miss Ellis, I'm gonna go ahead and swear you in, okay?
Yes.
Can you go ahead and raise your right hand for me? Are you Donna Ellis, the defendant in this case?
Yes.
Are you familiar with the exhibits and stipulations attached?
Yes.
You swear or affirm the same are true and correct to the best of your knowledge?
Yes.
Are you familiar with the jury waiver?
Yes.
And your attorney has explained to you your constitutional rights and you understand them?
Yes.
And it is your desire to enter this plea and waive your right to a jury trial?
Yes.
Okay, thank you. You can put your hand down.
Let's go on the record. This is cause number 2020 CR 6311, the state of Texas versus Donna Alice. Attorneys, please make your announcements for the record.
Yes, Your Honor. Luis Echeverria for the state of Texas.
Oral Besa for the defendant, Your Honor, Miss Ellis.
Miss Alice is appearing by video conference. Go ahead and tell me your full name.
Donna Lynn Ellis.
And Judge, the state does have a motion when the court's ready.
Okay, Mr. Echeverria, go ahead.
Judge, the state moves to waive and abandon count 1 and proceed on the lesser included offense of count 2, possession, controlled substance penalty group 1 under 1 gram.
Okay,
No objections, Your Honor.
that's granted. We will waive count 1 and proceed count 2, lesser included offense of possession less than a gram. Possession less than a gram is a state jail felony, Ms. Ellis. It is punishable by confinement in the Texas Department of Criminal Justice, the state jail facility. It also carries a possible fine of up to $10,000. Do you understand the range of punishment that applies to this case?
Yes, ma'am.
You have the right to a jury trial. You have the right to cross-examine all the witnesses against you. You have the right to remain silent. All of those are your constitutional rights. Do you understand those?
Yes.
When you sign this document that I have on the screen, you're telling me you want to give up those rights. Is that what you intend to do?
I do.
Is this your electronic signature?
Yes,
Are you a citizen of the United States?
I am.
If you were not a citizen, then I still have to tell you that a plea of guilty or no contest to this charge could result in deportation, exclusion from admission to the country, or denial of naturalization under federal law. Are you satisfied with the representation of your attorney?
I am.
Mr. Basile, does your client have a rational and factual understanding of the proceedings against her?
Yes, she does, Your Honor.
Has she been able to assist you in the preparation of any defenses?
Yes, she has.
In your opinion, is she mentally competent to waive her rights and enter into a plea?
In my opinion, she is, Your Honor.
I will accept the waiver of rights and make it part of the record. Ms. Ellis, on the screen, I have the plea bargain agreement that you entered into. It calls for Class A misdemeanor punishment with a state jail felony conviction. So you'll be convicted of a state jail possession less than a gram, but your sentence will be served in the Bexar County Jail. It's for 180 days pursuant to 1244. There's no applications, and the state has recommended that you participate in my program called Bexar County Gives Back. That program just basically consists of you performing community service hours with the sheriff's office for 4 consecutive Saturdays. And it wouldn't start this Saturday. It's a holiday. It would start the following Saturday. So that Saturday is July the 10th. Now, what we do is we meet on Thursdays by Zoom, and then we give you the assignment and you show up on Saturday. Do you have any physical limitations?
No.
You can do just general lawn work, pull weeds, pick up garbage? Yes?
I can.
Okay. Is that your understanding of the agreement in this case?
I believe so, yes.
Yes. Mr. Basile, is that your understanding?
Yes, Your Honor.
State, is that your understanding?
It is, Judge.
What is your plea to the charge of possession of a controlled substance in penalty group 1 less than a gram? Is it guilty, not guilty, or no contest?
No contest.
And are you pleading no contest because you have talked about this matter with your attorney and you believe it's in your best interest to do so?
Yes.
Are you doing this freely and voluntarily?
Yes, I am.
Has anyone forced you to enter a plea today
No.
or offered you anything in exchange for your plea?
No.
I will accept the plea of no contest. I find the plea is voluntarily made, and I will ask the state to tender its proof.
The state offers State's Exhibit 1 and all attachments pending any objection from Mr. Basile.
No objections, Your Honor.
State's 1 is admitted. Mr. Basile, are you satisfied the state complied with Article 3914?
Yes, Your Honor.
I will sign the discovery acknowledgement and make it part of the record. Give me a minute so I can read the evidence. In the meantime, Ms. Ellis, my probation officer is going to be chatting with you. Can you answer her chats, please?
Yes.
Thank you.
information.
Still on the bench. What's going on?
I just wanted to see how everything went, how it was at the fur house today, and just what happened.
Well, he's denying that released a statement. He said no such thing. Which I don't believe, because when I talked to Michael, it was very clear that Michael would not have known that Bella is coming up, or that Bella is pre-trialing your witnesses, and that this guy was a witness. Michael wouldn't have known any of that. I believe Michael.
Well, no, I mean, I believe Michael too. He did say it. So Michael told me that Robert Vargas called him. So I guess Dylan Collier called Robert Vargas back because initially Robert didn't know what was going on. He just knew that.
camera is off. There we go. We're back online now. Let's go back on the record. I do find the evidence is sufficient to substantiate your guilt, and I will find you guilty of the offense of possession of a controlled substance, penalty group 1 less than a gram. That's a state jail felony, and I will assess punishment at 180 days confinement in the Bexar County Jail. We're going to suspend that. You're not going to go to jail. You're going to participate in the Bexar County Gives Back program. Did you exchange all of the information with my probation officer, Ms. Ellis? Go ahead and unmute yourself, Ms. Ellis. You're muted.
I'm so sorry.
That's okay. So this is a plea bargain case. I did follow the plea bargain agreement. You do not have a right to appeal. Do you understand?
Yes.
Okay, thank you.
Thank you.
And you can still come on Zoom tomorrow. Did you get the Zoom link?
I did.
Okay, so you can still come on Zoom tomorrow. I'll talk to everybody and then I'll let you know what we're doing, but just come to Zoom tomorrow, okay?
Yes. Thank you.
Okay, thank you.
Bye.
Can I get 2 minutes and I'll call you right back? I'm just finishing up docket.
I do.
Yes.
Thank you.
Yes, I'll call you right back. All righty. Okay, we're all done for today.
Okay,
Thank you.
thanks, Connor. Just want to congratulate.
Okay, thank you for hanging in there with me.
I already signed. I was going to congratulate her for her dog being so good the whole time.
Yeah.
She's in the car with the dog. I hear what? I didn't even know what's there. That's a good dog.
It was, right? It was a good dog.
Like, the same when they pulled over, the dog was real good too. The police were commenting.
That's funny.
Congratulate her on that. Okay. Thanks. Sharon. Have a
Okay,
good evening.
see you guys soon. We'll see you guys tomorrow.